Don't you have to change something up here?
Oh, this might be it. Let me try this.
We've got the YouTube.
Don't you have to change something on the Zoom here?
I did. Oh, that's right.
Speaker, something. A steno, something.
Okay, Anna, you're still the host?
Where's my Okay, here we go.
Okay, I am back to being the host. Okay.
Test, 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 test. Hold on. I gotta get Moon Creek.
Mr. Lee, your microphone is on.
And Marlo.
Good for Amy.
It's a Miss. It's Miss.
I got it.
Amy.
Judge, can you say the quick brown fox jumped over the lazy dog?
The quick brown fox jumped over the lazy
I
dog.
can't hear you, Judge.
I can hear you, Elizabeth.
Okay, Patrick can hear me,
Test,
but you
test,
can't
test,
hear
test.
me?
Yeah,
You did something wrong here.
I did change it.
Can you hear me now?
Now you can't hear the judge.
Should be coming through my computer, I think.
Hello,
You
hello,
need to hear it
hello.
tonight.
Right. It might be on my end, Judge.
Patrick said that he can hear me, so I'm thinking it might be. How are we doing?
Test, 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 test. Uh-oh. Test, 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 test. Test, test, test. I got nothing. Who are we hearing? Who are we hearing?
What's the rating is quick, quick, quick.
All right, get out of here.
While Mr. Lee is
Believe it's
Test-
set up.
It's gotta be something on the Zoom. That way.
testing his equipment,
Did you pick the wrong one? It's right here.
Um, looks like most people are already admitted.
I forgot to.
There.
Does anyone have anything procedural?
Hold on, Jack.
Well, we're off the record, Mr. Lee. But you want me to wait?
Madam Hearing Examiner, we don't need this on the record, but we had requested in an email that Katrina Reed,
I
my
have no idea.
Yeah,
office assistant.
noted.
Okay, can she
Noted.
join then? Okay. Thank you.
Huh?
This is what I wanted to start.
Madam Hearing Examiner, can you hear me?
I can, Mr. Dome. Good morning.
Thank you. I was just checking the technology on our end, ma'am.
Okay.
Yeah, thank you. I appreciate it.
It's that thing. And it's
Get the other computer from downstairs.
the phone. So it's the thing that's pointing at me.
Good morning. Can everyone hear me? I was not getting audio earlier.
Yes, I can
Yes.
hear
Yes.
Thank you.
Thank you. Good morning.
you.
Good morning.
The phone
I'm not getting from.
might be Anna. All right, we're gonna have to do it the old-fashioned way. Gotta stop everything.
Just to let Zoom people know, we have started the YouTube live stream. And just as a preliminary matter, there are some procedural things from our pre-hearing that I will address.
I gotta sign.
I heard you go Bink.
I don't know, but I'm not ready.
How about this time, Mr. Lee?
I'm trying it.
Can you hear me this time?
And
Awesome.
give me a moment.
Take your time, sir.
The quick brown fox jumped over the lazy dog. Ask him if the quick brown fox jumped over the lazy dog. Test, test. The quick brown fox jumped over the lazy dog. I know what's going on now.
You have two Zooms open. Rapid by back.
I did.
Are you,
Test, test,
are you out of Zoom in that one?
test, test. Let me look.
No.
Test, 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 test.
You're good on my end, Mr. Lee.
Test, 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 test. The quick brown fox jumped over the lazy dog. They can't hear me. The quick brown
I can hear
fox
you.
jumped. The dog. It's the people who are working for me. Ask them if they can hear me. Test, 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 test.
No, no. Zero audio.
Test, 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 test. Judge, I still need a minute.
All right, Mr. Lee.
Test, 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 test. I need to restart my system. Test, 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 test. It's not picking it up. Judge, can I have 10 minutes?
Um, yes, sir. Yes, sir.
Test, test,
Uh,
test, test, test.
Parties.
See if they can hear her. Go, say something, will you, Judge?
Sure. Parties, we are gonna delay the beginning of our hearing for 10 minutes to get our court reporters sound system in operating order. So you may stay on the Zoom, or I can put you back in. Just remember, we are live on YouTube during this time. Thank you.
Everybody's resetting their system and starting.
Everybody's resetting their system and starting.
Madam Hearing Examiner, can I ask you a question while we're waiting?
Sure, Miss Nanasi.
Given your ruling, I'm going to need to readjust and take out. Do you want me to take out that exhibit from the filing and just take out any reference to that, like that footnote, or how do you want me to handle it in term and then upload it again? I just wanted to do what you want me to do.
Yeah, yeah. I mean, I think to the extent that your exhibit can comport with the ruling this morning, I mean, you have a few days
Yeah, sure.
probably to do that. But I wanted to make sure that you got the ruling in time for your cross-examination, potentially today or beginning tomorrow.
Thank you.
So yeah, to the extent that you can adjust your exhibit, please do so.
Okay, and then I just
Okay.
upload it onto Dropbox the way I did before, correct?
Yes.
Okay, and
Yeah, other people, I didn't realize that once I sent it back out that people could still add things, but they were adding things over the weekend. So you can too.
okay,
I'm ready, Judge.
okay, thank you.
Okay, thank you. All right. All right, Mr. Lee, we're good to go.
Yes, ma'am.
All right, thank you, sir. Good morning. My name is Elizabeth Hurst. Along with me is my co-hearing examiner, Patrick Schaefer. Good morning, Mr. Schaefer.
Good morning, everybody. Good morning, Hearing Examiner Hurst.
Along with us today is Mr. Lee, our court reporter. And if anybody needs anything to do with the transcript, they'll need to deal with Mr. Lee. We are here today along with Chairman Aguilara, who I see is also in the gallery. Good morning, Mr. Chairman. We're here today in the matter of the application of Saturn Utilities Holdco LLC for approval to acquire New Mexico Gas Company Incorporated. To date, is the date, time, and place for a hearing in this matter. I would like to, at this point, just advise people that we are on live streaming on YouTube. Therefore, during any breaks, unless you want whatever you're saying or your video on the live on the YouTube, then you're going to need to make plan for that. Additionally, I'd like to indicate for the record, Mr. Lee, that today is the date, time, and place for the hearing in this matter as set forth in the order setting procedural dates for a revised application that was issued by Hearing Examiner Schaefer and myself on July 11th. The initial notice was issued in this case pursuant to a procedural order that I issued on November 27th of 2024, wherein the joint applicants were required to provide a publication notice and individual notice to the parties. And that was accomplished pursuant to the affirmation that was filed by gas company with the commission on December 20th of 2024, and individual notice to customers, again, pursuant to affirmation of notice filed in the docket January 9th of 2025. Additionally, with regard to this hearing, the commission had its own public comment hearing that took place on October 28th, where the commission heard from persons with regard to the application in this case. At this time, I would like to get the appearances on the record. And I'm going to start out with joint applicants
Not aligned with the voices, but just
and Mr. Domi, if we could start with you.
yes, ma'am. I'm appearing today on behalf of the Amera entities and New Mexico Gas Company. And along with me appearing at the hearing is Brian Havert and Juliana Hopper from the Kelleher firm. And also appearing is Nicole Strausser, the General Counsel of New Mexico Gas Company, ma'am.
Thank you, sir. Ms. Hardy?
Good morning, hearing examiners, Mr. Chair. Dana Hardy, appearing on behalf of the BCP applicants, along with Mr. Rick Alvidrez and Mr. Will Dubois.
Thank you. Good morning.
Thank you. Good morning.
And I'm going to go in appearance to intervention date. And Mr. Najjar?
Good morning, Madam Hearing Examiner. This is Dan Najjar and Thomas Wyman appearing on behalf of the Incorporated County of Los Alamos. And at the appropriate time, we will make a request to be excused from participating actively in this hearing.
Yes, sir. Thank you. Ms. Nanasi?
Good morning, Madam Hearing Examiner and Hearing Examiner Schaefer and Chair Aguilar and colleagues. My name is Marielle Nanasi on behalf of New Energy Economy. Thank you.
Thank you. I believe, Mr. Harris, that the New Mexico Department of Justice was the next intervener in the case.
Yes, I'm here with, I'm Brian Harris. I'm here with Evan Crocker, and the two of us will be following this hearing, perhaps not both at the same time, however, as it progresses. If you want us to,
Very
either
well.
one of us, to excuse ourselves then, or just this blanket statement now, whichever your preference.
I will attend to your motion after we get our appearances, sir.
Madam Hearing Examiner, and just for the record, there may be one other attorney who attends on behalf of the Department of Justice. His name is Anthony Uzaitis.
Thank you. Mr. Gould, I believe NM area was next in intervention.
Yes, good morning, Madam Hearing Examiner Schaefer, Commissioner Chair Aguilar and parties. My name is Peter Gould. I represent the New Mexico Affordable Reliable Energy Alliance, known as NM area. My co-counsel, Joseph Yar, will be appearing throughout this hearing, and he is currently on YouTube.
Thank you, sir. Ms. Beatles, I believe WRA was next in intervention.
Good morning, Sydney Beatles for Western Resource Advocates.
Good morning. Thank you. Ms. Lynch, I believe CCAE was next.
Good morning, hearing examiners and Commissioner Aguilera. I am Kara Lynch representing Clean Affordable, or the Coalition for Clean Affordable Energy. I'm here with my colleague, Charles DeSayan, and we will be appearing throughout the matter according to the lead attorney covering the witnesses. So it's up to you, hearing examiner, whether you would like us to request times for attorneys where we'll be on Zoom or in the hearing room.
I'll deal with that after we get the appearances, Ms. Lynch.
Okay, thank you.
Thank you. Mr. Freeman, I believe that FEA was next in intervention.
Good morning, Madam Hearing Examiner and Hearing Examiner Schaefer. Jelani Freeman, representing the federal executive agencies.
Good morning. Thank you. Ms. Lynch, Prosperity Works also filed a motion to intervene. Are you
I'm
appearing on
appearing
behalf?
on behalf of Prosperity Works.
Okay.
Thank you.
Thank you. All right. I believe that, oh no, what one of the commission's most important participants, Ms. Hay, can you make your appearance for staff, please?
Yes, ma'am. Katie Lang, together with Ryan Friedman and Mr. Nicholas Rossi appearing on staff. Mr. Friedman is actually the lead attorney, but he was having audio problems earlier, so I think he's on. Oh, yes, he is. Mr. Friedman, if you would like to say anything, I
Nope, you did fine. Thank you. Yeah.
Very well. Good morning. Now I think I have all of the appearances for the record. Very well. Next, we should go on to procedural issues, and not in any particular order, but there was an outstanding order on confidentiality that was pending when we had our pre-hearing last week, and just wanted to announce to the parties that an order was issued last week with regard to that confidential issue. So let's see, the second procedural issue was whether or not joint applicants would have separate attorneys. Hearing Examiner Schaefer and I discussed this and looked back through some dockets, and the answer is yes, they can. The next procedural issue was from Mr. Gould's email over the weekend. Can we allow the tech people to help me with share? I've thought a lot about this. Normally, I don't share my share. However, in the spirit of learning new things, I'm going to share the share. I'm going to try sharing the share. So the answer, Mr. Gould, is yes. You can send your technical help the Zoom link.
Okay, thank you. And
I think
in that regard, if we posted something on the Dropbox, we can assume that the other party has it. We may not need to share, but there are some exhibits, so they're complicated enough. It would be helpful to get them up on the screen, but we'll try to minimize that. Thank you.
Okay. Ms. Nanasi wanted to know, can I borrow time from myself? Hearing Examiner Schaefer and I discussed it. Yes, you may. Motion in limine, the order was issued this morning. There's been a question to the extent that we can get that exhibit more readily in compliance with the order. Yes, please do that. let's see. So this is a question for those of you who added things to the Dropbox after we had the pre-hearing. And my question to somebody who did that is, could you just add them or could you delete your old one too? Mr. Gould, do you know the answer to that question?
Yes, what we did, and hopefully I'm answering your question correctly, is I sent our updated exhibit list to everyone in that email where I questioned, I sent the questions to you, and all we did, of course, as I explained in the email, is add an exhibit number 43 and 44, and these are the certifications in the prior cases. And I just thought it would be easier for my cross-examination if I could go directly when I'm talking to the witness to a exhibit that I knew was there, rather than all of us fumbling around with paper.
You didn't answer my question.
Okay, then I
You
missed it.
added something. You added something. Did you delete something?
No, I did not delete anything. Sorry.
Okay.
I added two exhibits, but
Yes.
didn't.
No,
Yeah,
I know you added. I'm just wondering if you
no
deleted.
deletions. Sorry for missing the point.
Okay. Mr. Rossi, you had your hand up?
I was going to answer that question for you, Madam Hearing
Yes,
Examiner.
sir.
We cannot see the list of exhibits, so we cannot delete them or anything like that. All we can do is add.
Okay, but I sent another link where you should have seen everybody's exhibits.
I was unable to locate that email.
Okay. Did your other staff members get it?
They did not.
Okay. Interesting. I will send it out to you again.
Thank you very much.
Madam Hearing Examiner, we did not get it either. I looked this morning.
You didn't get, well, then how did you add anything? Because I changed the link.
Well,
So you had to have gotten it.
we uploaded, but we didn't, we were able to upload, but and again, we were not able to see a link in the Dropbox where we could see everybody else's exhibits.
Okay. Is there anybody who got the link who could see everybody else's exhibits? Ms. Nanasi?
Yes, I can, but I cannot delete an old exhibit. So I can see them because it was sent this morning, the Dropbox link with everything in there, but I couldn't delete the old, what was my exhibit list.
Okay. That's the function I was going for. Okay. Well, I apologize for any confusion because it got sent to Mr. Well, I'm not going to go through that. That's going to waste time. At the break, I'll make sure I send it back again to everyone. Okay, I've got a couple of pending motions. Oh, well, one other procedural issue Ms. Lynch just brought up. Do I want to know if you're not going to be if you're not going to be participating in the hearing? I think the answer is yes. I think you could put it in the chat. You know, if you have to leave and you're you know, I guess if you're going to be
I just
not
yeah.
have representation,
Oh, well, it was for CCAE where we have two attorneys present and there would
Right.
always be representation.
Oh, okay. Yeah, that's fine.
Okay,
So no, the answer is no. Again,
okay,
understanding any party that isn't available waives or any counsel for the party waives the whatever happens while you're not there. Okay. Two pending motions and or requests. Mr. Najjar, have indicated that the County of Los Alamos has no witnesses, waves cross, and would like to be excused. Is that correct, sir?
Yes, ma'am, that's correct. Thank you, Madam Hearing Examiner.
And I think you sent that out last week or before. I haven't heard that anybody objects to this. Therefore, your request is granted, Mr. Najjar.
Thank you, ma'am.
Thank you, sir. Understanding, as I just said, you waive any thing that happens while you're gone, including the setting of any post-hearing writings.
Madam Hearing Examiner, yes, we accept those terms and we understand them. Thank you.
Very well, thank you. And then the other pending motion was filed on Friday, and that is a motion from the New Mexico Department of Justice to withdraw its pre-filed testimony of Mr. Garrett. And in that motion, it's indicated that NMDOJ doesn't have any cross-examination for the witnesses, but intends to observe the hearing and may file post hearing legal analysis. Don't see that any party positions were obtained on this, but parties could indicate if they had any objection to this. Hearing none. Mr. Crocker, looks like you raised your hand.
I did, though. It was not in relation to this. It was a brief question
Oh.
about video, so I can wait.
Okay. Not hearing any objection. NMDOJ's motion is granted with sadness. I go ahead and that's kind of my list of procedural things. You had something else about the video, Mr. Crocker.
I just had a quick question about Zoom video. I know you asked that we are on video as long as we are participating. Since we're not going to be active participants and I'm a division director, people may pop into my office for things. Is it okay
Sure.
to turn off my video during those moments?
Either that, sir, or you can go off the Zoom feed and just observe by YouTube.
Okay. Thank you
If
so
you want to
much.
do that. Thank you. Okay, has anybody got anything further procedurally that we need to discuss before we begin the evidentiary part of our hearing? Hearing nothing, I believe then we can move on and have our first witness. And I believe that pursuant to the agreement, I've got some more hands here, Mr. Rossi.
Madam Hearing Examiner, prior to the presentation of evidence, would it be possible for those of us that have not yet received the list of exhibits and be able to access them, would it be possible to send that out?
I will try again. Okay, so nobody got it except Miss Nanasi, is that what I understand?
Madam Hearing Examiner, I received it.
Madam
Okay,
Hearing,
Mr. Freeman.
Rick Alvedris on behalf of the joint applicants in this instance, we did also receive it and have downloaded everything.
Okay.
And Madam Hearing
Ms.
Examiner,
Lynch? Yes,
Not that I saw.
we're still waiting as well, Madam Hearing Examiner. I have,
okay. And I see you on my list, so I know it got sent to you. Um,
yeah, usually we don't have any, the internet connection is good. We don't have any problem with that, but we'll work it out.
The Dropbox connections. I did not.
no, Mr. Harris?
No,
Do you want it?
yes, please.
Madam Hearing Examiner, I don't see it in my inbox either.
Okay. It was sent Thursday, October 30th at 3:45.
Apologies, what was that date and time again?
Who said that?
October, Mr. Crocker.
Thank you, Judge.
I sent it October 30th at 3:45.
Madam Hearing
Okay,
Examiner, we do have it. Thank you. Sorry for interrupting.
and I just sent it to you again. Okay, and staff, I included you. I think I have everybody now. If not, chat me on the thing, and I will. I'll try to
Thank you,
include
Madam
you
Hearing
again.
Examiner. I did just receive the email you just sent, but it does not look like I was on the previous version. So thank you.
Thank you. Okay, I think we're ready for our first witness. And I believe joint applicants, pursuant to our list, are going to call Mr. Boudier.
That's correct. Hearing Examiner Schaefer and Hearing Examiner Hurst and Chairman Aguilera. I'm Rick Alvedris. I'll be presenting Mr. Boudier, and we would call him to be sworn right now.
Good morning, Mr. Boudier. Welcome.
Good morning. Thank you very much to the hearing officer and to the chair and all the parties present. Thank you for being here today.
Mr. Lee, could you please swear the witness, sir?
Mr. Boudier, would you raise your right hand, please? You solemnly swear that the testimony you're about to give the matter not pending to be the truth, the whole truth, and nothing but the truth.
I do.
And Mr. Boudier.
Thank you.
Sorry, may I proceed?
Yes, sir.
Mr. Boudier, can you state your name for the record?
My name is Jeffrey Michael Boudier.
And Mr. Boudier, where are you employed?
I am employed as the president of Saturn Utilities Holdco LLC, which is one of the joint applicants. And I'm also employed as a senior managing director for Bernhard Capital Partners Management LP.
And Mr. Boudier, we have 3 exhibits representing various testimonies of yours in this case. But can you confirm that joint applicant exhibit 1 is your pre-filed direct testimony?
Yes, I confirm that.
And can you also confirm that we prepared a confidential version of that same testimony that we've marked for identification purposes as Joint Applicant Exhibit 1A?
Yes, I can confirm that.
And were true and correct copies of both of those exhibits uploaded into the NMPRC depository?
Yes, they were.
And do they include exhibits?
Yes, they do. I think there's about almost 29 or 30 exhibits to the primary testimony.
Okay. And was your testimony or direct testimony, both the confidential and the public version, prepared by you under your supervision and control?
Yes, it was.
And do you have any changes or corrections to make to, let's say, Exhibit 1 right now?
Not to Exhibit 1.
Are there any corrections or changes that you have to Exhibit 1A, the confidential version?
No, there are not.
And to the best of your knowledge and belief, is your testimony true and correct?
Yes, it is.
And if you were asked the questions that appear in your testimony, would your answers be the same today?
Yes, they would.
Your Honor, we move the admission of Joint Applicant Exhibit A and A1 into evidence.
One and 1A, Mr. Alvidrez?
Yes, and 1A would be admitted under seal as a confidential document.
Yes, sir. Any objection to what has been identified as Joint Exhibit number 1? And so I'm pronouncing it correctly. Is it Baudier or how do you pronounce your name, sir?
It's Baudier, Your Honor.
Beau, like a bow. Okay. Baudier.
Yes.
Okay,
Correct.
very well.
Perfect. Perfect.
Mr. Baudier's revised application direct testimony as affirmed by him here today. Hearing no objection, Joint Exhibit 1 is admitted.
Thank you. Thank
Is there
you,
any
Your Honor.
objection to what's been identified as Joint Exhibit 1A, the confidential revised application direct testimony and exhibits that are currently filed with the commission under seal? Hearing no objection, Joint Exhibit 1A is admitted. And just so I can confirm, Mr. Alvidrez, with the exception of Joint Exhibit 2, are all of the bench request responses included in Joint Exhibit 1 or 1A?
Well, with one caveat, Your Honor, yes, for the most part, all of the joint exhibit responses that Mr. Baudier responded to are included in Exhibit 1 and 1A. Of course, 1A has the confidential information. Mr. Shell did also respond to one or two of the bench requests, and those are incorporated into his testimony that will be admitted later or presented later.
Oh, thank you for that clarification. Go ahead, sir.
Okay, moving on to Joint Applicant Exhibit 2. Mr. Baudier, did you prepare or have prepared at your direction what we've marked as Joint Applicant Exhibit 2, which is your third supplemental testimony of Jeffrey Baudier?
Yes, I did.
And are there any exhibits to that testimony?
I don't believe so.
Are there any changes or corrections to that testimony?
No, there are not.
And is your testimony true and correct to the best of your knowledge and belief?
It is.
And if you were asked the same questions as appears in that testimony today, would your answers be the same?
Yes, they would.
We move the admission of Joint Exhibit 2 into evidence.
Any objection to what's been identified as Joint Exhibit 2, Mr. Baudier's third supplemental testimony in response to the bench request, as affirmed by him here today? Hearing no objection, Joint Exhibit 2 is admitted. Go ahead, sir.
Yes, and finally, Mr. Baudier, did you prepare or have
Hearing
prepared?
Examiner Hurst.
Sorry?
Who said
This is Ryan
that?
Friedman on behalf of staff.
Yep. Mr. Friedman?
I do not see Joint Exhibit 1A in the Dropbox.
It is not in the Dropbox. Joint Exhibit, I have Joint Exhibit A, which, as we discussed on Thursday, when we talked about how it would be presented in a separate Dropbox, or if it would be presented to the hearing examiners via password protected email. And we decided that that is how it should have been provided, and it was in fact provided that way. Okay.
Do any of the parties have it besides the hearing examiners?
I'm sorry, who is
Well,
speaking?
Ryan Friedman on behalf of staff. Sorry, Mr.
You need
Baudier.
to identify yourself, Mr. Friedman, before you speak. Presumably, Mr. Friedman, during the course of the case, you were afforded the opportunity to review the confidential documents. And I asked at the pre-hearing on Thursday whether or not anybody planned on asking any questions about the confidential information, and indicated, to the extent we don't have to close our hearing, that I would prefer that we do that. Do you recall that?
I do. Ryan Friedman on behalf of staff. Yes, I do. Hearing Examiner Hurst. I have some concerns about not knowing while they're saying Exhibit 1A has been submitted to you, I don't know what's in Exhibit 1A as it's been presented to you. That's where my concern lies.
If you look at the pre-hearing memo from the joint applicants, I believe, Mr. Friedman, they have indicated, I don't have it in front of me, but I believe they indicated which exhibits were contained in the confidential filing. Ms. Hardy, is that correct?
Your Honor, this is Rick Alvidrez. I can address that.
Oh, go ahead, sir.
When the revised testimony, direct testimony of Mr. Baudier was filed on July 3rd, we also made available the confidential exhibits that were attached to the confidential version of his testimony. So the parties who have signed the confidentiality agreements pursuant to the protective order have had access to those confidential exhibits. It is in a confidential folder, but the testimony itself does not include any confidential information. The only confidential information was contained in the exhibits, and those have been posted since July 3rd.
Is there any change in what's been posted in July with what I was provided access to on Friday?
No, Your Honor.
Okay. Does that answer your question, Mr. Friedman?
Yes, Madam Hearing Examiner, thank you very much.
Very well. Okay, let's go back to joint. Mr. Alvarez, I think you were about to deal with joint exhibit number 3.
That's correct, Your Honor. I'll proceed.
Go ahead.
Mr. Bodier, did you prepare or oversee of joint applicant exhibit 3, which is your revised application rebuttal testimony dated October 10, 2025?
Yes, I did.
And do you have any changes or corrections to make to that testimony?
There is a correction to delete some erroneous testimony that related to Mr. George's exhibits. And I believe we filed to request that those be stricken from the rebuttal testimony.
Well, can you describe the page number and line number where those that testimony is proposed to be deleted?
Yes. Let's see. I'm looking at my rebuttal testimony here.
Page 44.
On page 44, the language starting at line 4 through line 11 is erroneous, and we're requesting that it be stricken.
Okay. And
Okay, wait a second. You want to strike line 4 through what?
Through 11.
And you want to strike it because your testimony's not correct?
It is the last sentence, Your Honor, which says that the inclusion of these violation letters for entities unrelated to NWI or BCP confirms that Mr. George was careless in his claims. That's incorrect. They are erroneously included. However, they were erroneously included by NWI in producing the documents. They were mistakenly collected along with documents that did relate to NWI. And so the mistake was on NWI, not Mr. George. And they were produced to Mr. George in the manner in which NWI had pulled them. So the mistake was with NWI. And to the extent that I referenced that, the mistake was mine.
Okay. Any other revisions to your direct or your rebuttal testimony?
No, Your Honor.
Go ahead, Mr. Alvarez.
yes, and Your Honor, I believe that the version of the testimony that was uploaded has that language struck.
Oh, okay.
So, Mr.
Great.
With that correction that you've noted, is your testimony true and correct to the best of your knowledge and belief?
Yes, it is.
And if you were asked the same questions that appear in the testimony subject to the correction you just made, would your answers be the same?
Yes, they would be.
We move the admission of Joint Applicant Exhibit 3.
Any objection to what's been identified as Joint Exhibit 3, Mr. Baudier's corrected, revised rebuttal testimony filed on October 10th? Hearing no objection, I have an issue with Joint Exhibit 3. And it happens to be an objection that I have given more than once. And it has to do with the proper nature of rebuttal testimony. pursuant to the commission's rules of procedure 1.2.2.35 in rebuttal testimony is rebuttal evidence, which tends to explain, counteract, repel, or disprove evidence submitted by another party of staff. Evidence which is merely cumulative or could have been more properly offered in the case in chief is not proper rebuttal evidence. And what I'm looking at is Joint Exhibit 3, pages 5, pages 6, and the first 4 lines of page 7. And the section is entitled Benefits of the Transaction. And at line 30, do you have any introductory comments concerning the benefits of the transaction? I do not find that that testimony comports with the definition of rebuttal testimony. It does not, as required, explain, counteract, repel, or disprove evidence. It appears to be a repetition of testimony that Mr. Baudier filed in his direct case. Any explanation for that, Mr. Alvidres?
Yes, Your Honor. It is contextual information that kind of, sets up the rest of the testimony. Of course, on page 6 at line 7, we specifically say, contrary to the claims of certain parties in the case, the BC applicants are financially strong, etc. But what we've had is sort of some themes that emerged in the testimony that was filed in opposition to the application, and this section leads in with providing the context and why they're incorrect in what their statements are. As we said, we rebut at page 7. We talk about there's been a lot of discussion too about why Emera is a better ultimate owner than BCP. And much of the section here is to talk about why BCP is, in our view, I'll speak for the BCP applicants, better suited under the circumstances to own NMGC. And that's when we get into the issue about, where Emera is located versus where BCP is located, that Emera is interested in divesting BCP, and that Emera is interested in divesting NMGC, and that BCP wants to be here. That's in direct response to the parties that claim, well, Emera is a much better candidate to continue to own NMGC than is BCP. So that's why that testimony is included there.
Well, perhaps then the structure of the question might have been different, rather than appearing to provide a repetition of direct testimony. With that explanation, and with the caution that I give not only joint applicants, but also all parties, please make sure your rebuttal testimony is actually rebuttal testimony. Having heard no objection to Joint Exhibit 3, I will admit Joint Exhibit 3 into the record. Go ahead, Mr. Alvidres.
Your Honor, that concludes the exhibits for this witness, so we would tender him now for cross-examination.
Mr. Lee, how are we doing? Is this a good time to take a 10-minute break before we begin?
Yes, Your Honor.
Okay, we're going to take a 10-minute recess. It is 10:27. So let's come back at 10:35. Remember, you are on the YouTube. Are we good, Mr. Lee?
Yes, Judge.
Thank you, sir. Mr. Friedman? Was that from before, or do you have a new question?
I do have a new question, trying to get my video back on. It's actually stem off. So I'm struggling to get a lay of the land with the exhibits since we didn't get the link on Thursday. And I was looking for 1A, and because the previous exhibits they'd sent to us in the past are not labeled the same, I'm having trouble figuring out which is actually 1A. So my request would be either we can have access to the one they sent you, or if the joint applicants can describe what the previous document title was so that I can view the one they had previously sent back, I believe, in July.
Your Honor, may I make a proposal that
Hang on
may
one
benefit?
second. Yes. Okay. Go ahead, sir.
So we will be happy to upload on the confidential site 1A as was submitted to the commission last week, so that everyone will have a complete copy of the exhibit as it was submitted to you.
So basically what they're saying is they will send you the same password kind of protected link that that
No.
the hearing examiners were sent. Mr. Friedman?
No, it's a different process, if I may, Your Honor. There is a SharePoint link that all parties who have signed the confidentiality agreements have access to, and we will post it in that database.
Okay. Is that what was provided back in July?
Yes, that's where those documents reside as well.
Okay, so
And will you
basically
upload it?
you're re-offering the same thing you offered in July.
Not exactly. As I said, the exhibits that are confidential were posted in July, so they have access to the exhibits, and they have had since July. We're just going to upload the entire testimony as was submitted to you.
Okay.
So it's one package for everybody.
Okay.
And Madam Hearing Examiner, I think it will be identified as Joint Applicants Exhibit 1A, so that
Okay.
it clarifies that that is the exhibit, but it's going
Okay.
to be shared on the SharePoint for all the confidential parties that have signed a confidentiality agreement.
Okay. So the nomenclature is going to be the same, so he'll understand what it is.
Yes.
Thank you. Mr. Friedman, will that help?
That will most definitely help. Can I ask when that'll be available for us to view?
Madam Hearing Examiner is going in right now.
Thank you very much.
Momentarily.
Momentarily.
Okay. Very well. Before Mr. Elviders, I can't. Have you passed your witness?
Yes, Your Honor, we did pass our
Okay.
witness for cross.
All right. Let's see. I have a request with regard to Joint Exhibit 3. It is my understanding, having reviewed Joint Exhibit 3, and specifically looking at page 48, the table on Joint Exhibit 3, It appears to me that Mr. Bodier, as indicated on the table on page 48, joint applicants have made some more commitments that they hadn't made in your revised direct. Is that correct?
Your Honor, it is, as you see, it's in response to issues that the parties raised. In that column that says response to parties, there's additional monetary benefits that are included.
Right. I didn't hear Mr. Bodier say that.
Yes, Your Honor, that is correct. That upon reading the testimony of the interveners, these are responding in essence to provide additional benefits that in most instances were requested or sought to be as proper, I guess you'd call them remedial actions in the intervener's testimony.
Okay, but they were not included in your initial revised direct, correct?
Not these additional items. You're correct, Your Honor.
Okay. Are there other benefits or concessions joint applicants have agreed to make in addition to the ones listed on this table, which refer to being monetary benefits?
There are several, Your Honor.
Okay. I would like a list of them. I would like joint applicants to prepare the list of all the, and you can term them however you interpret them, whether or not they're additional commitments, concessions, or whatever. So consider that a bench request, Mr. Alvidrez.
Absolutely, we're happy to do that, and I think most of them are found on between pages 14 and 19, but we're very happy to break those out in a separate exhibit and submit that to you. May we do that tomorrow?
As soon as we could have it, it would be great. It would be great if it's today, but
I
if
mean,
we
I
can't,
don't know if it would help. I'm sorry.
We'll
as soon as possible.
get it to you promptly. Thank you.
Okay, thank you. And with that, you wanted to respond, Mr. Bodier?
I was going to say, Your Honor, and I apologize for interrupting, that I could just walk through them. I had listed them myself or indicated where they are in the testimony, but if the list is sufficient, we could do that as well. Whatever is the preference.
You'll probably be going through them potentially in your cross. I prefer a list just because we have a commitment list already, and then I will consider it like a supplement commitment list. Okay.
Understood.
But thank you. Okay, with that, again, in the parties agreed to a particular order of cross-examination that doesn't follow the usual intervention date. Hearing examiner Schaefer and I didn't see this as problematic. Our only problem is trying to squeeze all the cross in during the hearing days, and so we're going to begin with Mr. Gould and NM area, who the parties agreed would cross-examine first. And just so that parties understand, I did put a limit on the cross-examination time, and we'll be trying to keep track of the 5-hour limit that was placed. So with that, Mr. Gould, if you would like to cross-examine the witness.
Yes, Madam Hearing Examiner. I do apologize at first. I've got a little bit of hoarseness, so hopefully I won't be clearing my throat. I'll mute myself when I have to clear my throat. I do have one request. We are going to make every effort to complete Mr. Baudier in the 5 hours, but if I do need to borrow an hour from the cross-examination time that we
No.
have for HUD, I thought you said we could we could borrow from ourselves.
You can borrow from yourselves, but I put a 5-hour limit on
Okay.
any witness.
Okay. I didn't know how that would work. Okay. We will live with that. The other question I have to you, Madam Hearing Examiner, and given the sheer volume of stuff in this case, I may have missed it. I did not see a final order, or I guess I just call it an order that has all of the witness times on like a spreadsheet. Usually I've seen that in these hearings where we have like one page that shows every single party and then how much they have been allowed for each witness. And I couldn't find that anywhere. Do you have that document, ma'am?
I have that secret document, Mr.
Ah,
Gould.
could we?
But I can provide it to the parties.
Okay. I just didn't know if it was one more thing I missed.
No.
Okay.
Ms. Kippenbrock and I worked really hard on that document, but yeah. I mean, I guess I can share that. It doesn't have any confidential information on it.
Okay. Thank you.
All right.
Yes.
Go ahead, sir.
Okay. Good morning, Mr. Baudier.
Good morning, Mr. Gould. Good to see you again.
Good to see you. This is the third time. We've had a couple of depositions in the case, so we might be referring to those through your cross. I did want to say one thing at the outset. There's a lot of material in this case, and I might be jumping around a little bit. So if my transition from one topic to another isn't clear, please let me know so that I can clearly guide where I want to go. It's incredibly important case, and we want to have a clear record. So if we can just proceed with that understanding, we can move forward.
Yes, sir, I understand, and I will do that.
Okay. On the same note, if I ask a question that isn't clear, I'm sure that your attorneys will object, but if they don't, and if there's a need for clarifying my questions so we can have a clear record, just let me know, and we'll go back and try to make my question as clear as possible. Okay?
Yes, sir, I understand.
Okay. I wanted to, before I got into some of the introductory questions I had, I did want to go to your rebuttal at page 6, one of the pieces of testimony the hearing examiner was just referring to. I'm looking at page 6, lines 13 through 17.
Yes, sir, I see that.
I'm going to just read that paragraph into the record so that we both know what we're talking about here. You state a primary customer benefit of the transaction is that the BCP applicants
I'm
want
sorry,
to.
sir. Could you start again, please? You state.
Okay. Am I not coming through clear, Mr. Lee?
I think it garbled on my side, but go ahead, please.
I will talk a little slower then. A primary customer benefit of the transaction is that the BCP applicants want to own NMGC and invest in New Mexico, while Amira wants to divest from New Mexico. There is an inherent benefit to customers from NMGC being owned by a company that wants to invest in NMGC and New Mexico. This is an important benefit of the transaction that staff and interveners fail to acknowledge. I read that correctly, didn't I, Mr. Baudier?
Yes, sir, you did.
When I read this, it troubled me because so I wanted to ask you a few questions about it. You understand that when Amira took over TICO, it accepted all of the terms and conditions that TICO had agreed to in the prior acquisition. Is that your understanding?
That is my understanding.
And one of those was the 10-year hold commitment. Are you aware of that?
I believe so, yes.
And were you also aware that the 10-year hold commitment was a minimum commitment? In other words, Amira was not promising that they would get out on day one after 10 years. They were holding it for at least 10 years. Is that your understanding of that commitment?
I haven't seen it precisely, but but I have no reason to disagree with you.
And you have been involved with personally with a utility up in Colorado, which I think had 20,000 customers and had a service territory. It was a co-op, right?
Core Electric Cooperative, yes, I was CEO. We had about 180,000 customers.
Okay. And you were there for what, 2 or 3 years?
I was CEO there for 3 years, correct.
Okay. And I'll return to that, but so that is just a setup for my question. You understand what is called the regulatory compact?
I have an understanding of it. Yes, my own understanding of it.
Why don't you tell me that, what you understand the term regulatory compact to mean?
When I think of the regulatory compact, what I understand it to be is that a utility, a regulated utility, gets a service territory, gets either a certificated or a somewhat of a territory or a natural monopoly to serve a specific area. It also has the obligation to serve that area, so it cannot deny customers who come into its area. And then in exchange for that, it agrees to be regulated by typically a state commission, and that regulation will not only impose certain requirements upon the utility, but it also will set forth a regime under which the return of and on the investments by that utility are recovered from the ratepayers.
Well said. And as part of that regulatory compact, would you agree that the duty of the utility under its obligation to serve is to provide reliable, efficient service?
Yes, I would agree with that.
At reasonable and affordable rates. Those are also regulatory rules. So would you agree that as well?
Yes, I would agree with that.
And as part of that obligation to serve that you mentioned, the utility has a duty within reasonable limits, of course, to build out its system to meet load growth. Would you agree with that?
Yes, I would agree with that.
So that was my concern. Are you saying here that if this particular transaction is not approved by the commission, are you saying that Amira will essentially not fulfill those basic utility obligations?
No, that's not my intention. I believe that Amera has, in the history of its indirect ownership of New Mexico Gas, has lived out that compact very well. I believe that it would continue to do so to the best of its ability if it remained the owner of New Mexico Gas Company.
Then what what precisely, with respect to this testimony, do you mean? What would, if BCP was approved as the owner, the direct and indirect owner of gas company, what would you do that Emera would not do?
Well, with this particular testimony is getting to is perhaps two things. One is more of the intangibles of how someone approaches an obligation when they truly want that obligation, when they truly want to assume that obligation, versus a party who may be trying to leave that obligation. And so, on the one hand, someone can perform its obligation with enthusiasm and look for the best possible ways to do it. On the other hand, a person could perform their obligation to meet that obligation, but maybe not go above and beyond. And I don't want to impugn New Mexico, the Emera operation of New Mexico Gas Company in any way. However, it's just to point out the fact that they do want to exit this investment at this time for valid reasons. As you've pointed out, they've met their minimum hold obligation. They do want to invest, as they've stated, in other utilities and in other jurisdictions. And so that is their intention, and they want to focus their investment on other assets. At the same time, what we've seen historically and we're seeing today is that oftentimes, if a utility has rejected the ability to sell their asset, but they want to exit, they will continue to try to. And so that's what you see, for example, in the TX&M transaction, where we were only maybe 18 months after the prior rejection of the Avangrid sale, where it's up for sale again. So my expectation would be that if this transaction is denied, Emera will try again sometime in the future to divest itself of this asset again.
Yeah, and that really wasn't I appreciate that testimony, but I guess maybe I need to ask a better question. The inference here, and I don't want to improperly read into your words an inference that you do not intend to convey, but the inference is that, if I could just use a common expression, that Emera is going to take its foot off the gas, that things that they would do if they were going to keep it for 20 years, they're not going to do. That improvements to the system may be related to their improvements in their replacement of legacy pipe that's no longer under code, that they would do less of that. And that would devolve into less efficient, less reliable service. Can you, and that's what I'm trying to get to. Is that what you're saying? That they're going to do less than they need to do, or less than what they've been doing the last 10 years?
I don't have any reason to believe, or based upon my relationship with Emera, I have no reason to believe that they would do less than they need to do. Question is whether they would do more than they need to do. And I think that's sort of what I'm getting at, is the difference between an enthusiastic new owner with that energy as opposed to someone who maybe has a different perspective. But I'm not suggesting in any way that they would not live up to their obligations.
Can you give me an example of what that more might include on BCP's part that wouldn't be attempted by Emera if this transaction is not approved?
Yeah, there are a number of commitments that we make in here, obviously. So we're increasing benefits to customers, including economic development, as well as low income support. We're obviously continuing things like charitable donations and efforts which have been ongoing historically by NMGC, despite sort of the obligation of that having passed. But I would also say that, and so that some of those benefits, which are the exact benefits being promoted by this, by us in this transaction, including, for example, the upgrade of the IT system to a new, more efficient IT system, they might not be either continued or executed upon by Emera, or perhaps not in the same way. And I also, although you mentioned that the utility does have an obligation to respond to growth and to invest in the system in response to growth, a utility who is also inclined for the long term and you know, like I said, coming in new and wanting to make investment could also help to encourage and promote growth within the state of New Mexico that would also be beneficial to New Mexico Gas customers.
Have you had any conversations surrounding this topic that we're discussing with the managers or ownership?
No, sir, I have not.
So as we sit here today, what you're saying is that your acquisition would provide more benefits than are currently being seen by customers, and that's really the what you're talking about, the economic development or that new commitment with respect to I think workforce training.
Those are certainly parts of it, as I've outlined in my prior answer. Yes.
But you realize that, and we'll get into some of these details later, but that when Emera came in 2015, they promised and delivered $20 million for economic development, and you've only promised 10. So that's
Is that a
not,
question, Mr. Gould?
yes, that's not, here comes the question. That's not an improvement on the prior deal. That's actually a devolution of the prior deal. Wouldn't you agree?
No, I would disagree, because your question assumes that that the test is to improve upon a prior deal. The test is to provide benefits to the customers today. And the test is whether or not this transaction will provide benefits to customers if it were to be approved. And that test does not rely upon a comparison to a prior benefit that may have been part of a prior transaction.
Okay. Well, we'll get into that because I do want to compare what was provided by TECO and Emera and what was approved as the level of benefits by the commission in those cases. But I want to get into that later in my cross-examination. So if I could go back to some more high-level questions. Can you tell me how long you have been working in your current positions at BCP?
Yes, I actually had a broken tenure at BCP, so I've had two different stints there. That total at this point, I would say just over 4.5 years. But I first came to BCP in 2018. And as you pointed out, in 2021, I left BCP to take the role as CEO at Core Electric. And then I returned to BCP in early 2024. And so I've been back in a more elevated role as Senior Managing Director. My prior role was Managing Director, in a more elevated role for about over a year and a half. I think April or May of 24 is when I returned.
Okay. And what I want to do is look with you at I have a few questions about the organizational chart, the post-close organizational chart, which is in your direct testimony on page 27. And if I refer to your direct and rebuttal testimonies, we both understand that these are the direct was filed on July 3rd of this year, and the rebuttal was filed on October 10th. Okay. So look at that org chart if you would tell me, if you would let me know when you're there.
Yes, sir, I have it.
Okay. I guess my overall question is this org chart accurate? Does it show, and my specific question is, does it show all of the ownership interests, either direct or indirect, in gas company post-close?
Yes, it does.
Okay. The top of the circle is are three what are called infrastructure funds. Do you see that?
There are three entities that
Three
relate
entities.
to one fund. Correct.
Well, explain that. I see three entities. I see, and I thought there were separate funds. And I'll read them. BCP Infrastructure Fund 2 LP. Then the next one is BCP Infrastructure Fund 2A LP, and then BCP Infrastructure Fund 2 GP, which I assume means General Partner LP. Did I read that correctly?
That is correct.
Are they in your mind, or are they legally, are they all one entity? Are they considered one company?
One question. Go ahead, sir, if
They
you
are
know.
they're separate entities. However, we think of the fund, although the fund is an aggregation of these three groups of investors. So including the limited partners and the GP, the general partner.
So let me see if I understand. So all of you would basically, if you were talking just casually to somebody, you would say, we have an infrastructure fund that incorporates three entities. Is that what you're saying to me?
That is correct.
Okay. What is your role in that top level, that fund?
My role, there's two possible roles. I am a limited partner in BCP Infrastructure Fund 2 GP LP.
Okay.
So I am a limited partner of that organization. And although it is not an owner and has no ownership rights, that GP has contracted with Bernhard Capital Partners Management LP to conduct the day-to-day management of the fund, and that is the entity by which I am employed.
And you're saying that
Hold on just a second, Mr. Gould.
Yes, ma'am.
But Bodier, did you just say that the fund is not the owner?
No, sorry, Your Honor. The fund is the owner. BCP Management, which is a separate entity, BCP Management LP is not an owner. It's simply a manager contractually to the GP.
Okay, thank you. Go ahead, sir.
And repeat that name, would you? BCP Management LP, is it called?
It's Bernhard Capital Partners Management LP.
And where is that? Is that shown anywhere on this organizational chart?
It's not shown on this chart. There is no ownership from BCP management.
So it's simply a contractor. Is that what you're stating?
That is correct, who serves at the pleasure of the GP.
Okay. And how big is that management? How many partners are in there?
There are 5 partners, about 45 professional employees, including myself.
Okay. But you're one of the partners. You're one of the 5.
I'm not a partner. I'm a managing director.
Okay. Do you or in that company, that management company, do any of the individuals in that company have a personal ownership, either direct or indirect, in New Mexico Gas Company?
Indirectly, a number of us would, through our obligations as limited partners of the GPLP. So if when you see that bottom entity that we refer to as Infrastructure Fund 2 GPLP, a number of, when I mentioned to you, I was a limited partner of that organization. Yes, I have an ownership interest in and an obligation to, as in the what we call the GP commit. So the general partner commits a small percentage of equity to the fund, and I participate in those obligations and benefits.
Would you be able to, as we sit here today, to give me a list of and the percentage ownership of the limited partners in that GPLP fund?
Let me ask first, would that be confidential information?
Yes, it would be.
Okay.
Who said that?
That was Mr. Alvidrez, Mr. Lee.
And who answered?
Mr. Baudier.
Thank you.
So your individual ownership is confidential.
That's correct.
But you will have an individual ownership through that, and just make sure we get it right, BCP Infrastructure Fund 2 GP.
GPLP. Yes.
GPLP, excuse me.
Sorry.
Okay. And how many other individuals would have a similar interest? And if you can't name them, I just want a number.
Yeah, I don't know. I know it's a number of us throughout the firm. It's a very common practice in private equity that employees at a certain level participate in this commitment. I can't give you an exact number of the, say, 45 employees who participate. I'm not privy, actually, it's confidential as between the LPs as to what another person may or may not own in many instances. So I don't know exactly what the breakout is.
Is there?
Hang on just a second, Mr. Gould.
Sorry.
Mr. Baudier, when you said the firm, are you still referring to whom? Are you referring to Bernhard Capital Partners Management LP?
Yes, Madam Hearing Officer, I should have been more clear, but that's who I referred to as the firm, the management company, correct?
Thank you.
Go
ahead.
Thank you, Madam Hearing Examiner. Do you have another question on that issue before I go ahead?
No, sir.
Okay, thank you. And I want to wrap this up, and I do not underline that. I don't want any confidential information. So if you can answer this question without revealing any confidential information, I'd appreciate it. Do you know what the total amount of the ownership in this transaction is with those individuals that have those small ownership pieces?
I do know it is confidential, but
Okay,
it is a very nominal percentage of the total fund amount.
Okay, and the total fund amount is the 2 billion that you've testified to in your direct testimony, correct?
Yes, sir, that's correct.
Okay. Couple of final questions on this point. Did you, if you can say, and the other persons that have these ownership interests, did they have to pay into the fund in order to acquire that interest?
Yes, sir, we do.
Okay.
We get a capital call. At the same time, all of the investors get a capital call, and we have, like all the LPs, 10 days to deliver our funding into the into the fund for the
Okay.
payment.
And do you have, you had mentioned, I think, when you were introduced, or your attorney mentioned that you have obligations at Saturn Utilities Holdco LLC. Am I accurate in that?
Yes, sir, I'm the president of that entity.
And as president of Saturn Utilities Holdco LLC, do you have any additional ownership in this transaction?
No, sir, I do not.
And what are your duties? Are you simply sitting on a board, or do you have active duties as the president of Saturn?
Not really active duties. There are no employees. There's no business of this entity except to hold. This would be the entity that could potentially hold debt. So, for example, the holdco debt would be held at this entity. However, there are no employees. It exists to be the owner of Tico Energy LLC, and as the president of that entity, it's a simple executive function to do things like sign documents and authorize other transactions on behalf of that entity and serve as a representative of it in a legal capacity.
Okay. In terms of the fund, it is not fully funded as yet, is it?
No, sir,
The
it's
fund
not.
at the top? Okay. What is the current funding at the top level?
I believe that's also confidential information.
I think you had it someplace in your testimony, and I was just trying to find it, and obviously, oh, here we go.
Oh.
Would you look at page 29 of your direct?
My direct.
And I'm looking at the Q&A that starts on line 10.
Oh yes, I'm sorry. You're right. It is in there.
Now,
And
when
this
this was,
is actually referenced.
go ahead.
This is obviously at an earlier point in time. It's changed since then, but well, it actually works out to be about the same. So yes, at the time this was stated, actual or committed fund of 455 million, and then there's additional reference to the raising of the additional 2 billion, and then a reference to the amounts available with the parties who are providing the equity commitments.
What is the process that you will undertake, or the management committee will undertake, to get the full funding of 2 billion?
We are in the process that is part of my duties, as well as others, of what we call fundraise. So during that fundraising period, we meet with private, sophisticated investors who are potential limited partners. In the great majority of our limited partners are pension funds, retirement plans, employee retirement funds, who have bodies of money, who have pools of money to invest on behalf of their retirees and pensioners. And we meet with them to discuss the thesis of the fund, the plans for the fund, and to raise money from them to participate in the fund.
And that process you anticipate won't be completed till the second quarter of next year. Is that a fair
That
summary?
is correct.
Okay. Um, the question I want to ask Ness is, you have a statement on line 16 that says, moreover, in addition to the above amount, which is the 455 million, the purchase of NMGC is guaranteed by equity commitments from other BC management funds, having approximately 635 million currently available.
Yes, sir.
I read that correctly, right?
Yes, you did.
And I'm going to kind of flip back and forth between a couple of things here, but first I want you to go to your table JMB1. I think it's on page 95. Of your direct.
Oh, on page 95.
Yeah, page 95. You've got a table that starts at the bottom of 95, goes all through 96, and ends at the top of 97.
Yes, sir, I see that.
Which funds in this is, let me ask a preliminary question. This table provides a complete picture, does it not, of all of the BCP funds, the infrastructure funds, and then the other funds that are grouped together under Bernhard Capital Partners?
It certainly provides a complete picture at the time of the funds, as well as the investments within those funds. There may have been in certain of the funds either potential investments since this chart was prepared, but I would have to comb through it carefully.
Well, I don't need that kind of level of detail. What I wanted to ask you was, if you could you identify which specific non-infrastructure funds are committing this 635 million guarantee?
Well, one of them that's committing part of it is BCP Fund 3 LP.
And that's at the top of page 96, right?
It's showing in several locations throughout the chart.
Okay.
And then the other equity commitment provider is an infrastructure fund, and that is identified. Let's see, it's definitely identified on page 97. Oh, you can see it on 96. BCP Infrastructure Fund LP. We call that Infra 1, but it doesn't really have the Roman numeral in it because it was the first one.
Is that the one next to the name Clear Current?
That is correct.
Okay. Have you decided, or have they committed specific dollars each one of those funds, or is it something more general?
Now, the equity commitment, which is provided within the confidential documents, is a very specific undertaking to agree to effectuate the closing at the equity amount listed in the commitment proportionate to those parties. In the event that Fund 2 did not deliver that equity.
Okay. You recall that on September 12th of this year, my co-counsel Joseph Yar conducted a deposition of you via the Zoom platform, I think it was.
Yes, I do remember that.
That transcript of that deposition is listed as Enameria hearing exhibit number 18 on our updated list of exhibits. Could you find that, please? I have a couple of questions about some of the statements that you made in that deposition.
I do have that deposition.
Okay. Could you turn to page 65 of that deposition, please?
Yes, I have page 65.
Okay, and what I'm looking at is basically the portion of 65 that starts on line 1 and goes down to line 19. But the setup for that particular Q&A was Mr. Yar asking you about these guarantees from the BCP fund number 3 and the BCP fund 3. And so he asked you, okay, the guarantee, as you probably understand, has legal connotations. Is that a written agreement? And you say there's a commitment made by other fund entities, correct? Did I read that correctly?
Yes, I'm sorry, and I'm looking at a condensed version of the deposition, but my page 65 is not aligning with your
Okay,
page 5.
Yeah, I
maybe-
apologize for that. I
Hold
know there
on.
were, go ahead.
She has given me a different version of the actual, I guess, final draft. So,
Yeah.
okay,
when you get to that, let me know. Take your time.
This is my testimony. He's talking about this deposition.
Yeah, if you can access it through the Dropbox, it is our hearing exhibit number 18. It should be the correct.
Let's have the page number on each of those little 4.
Yeah, but my page 64 does not have what he's referring to.
What about page 65?
Yeah, it's 65.
I'm 65, I'm sorry. Yeah, my page 65 starts with the question, okay, so how will it provide support?
She's pulling up 18 right now.
Okay, we'll just.
She's trying to locate the correct page at this time. I mean, the correct depth. I might just have a bad draft or something.
No. There were some initial drafts, and then there was a final draft, and I made that. I had trouble with that on one of the other depositions with my witness. So take your time so we can be sure we're clear. And I just have a couple of questions about this issue, and then we can move on.
The page 65 that you're speaking about, Peter, starts with okay and
Exactly.
the guarantee. Okay.
Yeah, exactly.
Okay.
And that was Mr. Dome for Mr. Lee's.
Yes, I'm sorry.
Yes, I've found that part of my testimony.
Okay, so why don't you, just to refresh your recollection, review lines 1 through 19, and then I can ask you a couple of questions.
Yes, sir. I've read that section.
And I know you're not an attorney, or perhaps you
Actually,
are.
I am.
You are. So we, but he asked you the legal connotations of that guarantee. Mr. Yar went on and said, asked you, middle of the page, is it a guarantee in the way I, as a lawyer, for example, would understand a guarantee, meaning a security interest? And you answered, security interest may be very specific, a very specific definition. I would say it's a guarantee in the sense of if you co-signed a loan for your daughter or son to buy a car and the bank said, yeah, but if you don't pay, you've got to pay, which is the guarantor. So it's a guarantee in that sense. Did I read that relatively accurately?
You did read it accurately.
Okay. Then if you would flip over in that same deposition to page 95, and I'm looking at line 16 through 23.
What number is this, sir?
This, the exhibit, the hearing exhibit is NMR exhibit 18, which is the September 12th deposition transcript of Mr. Baudier's deposition
Thank
by
you.
Joseph Yar, and I'm looking at page 95.
So yes, sir, I have found and looked at page 95.
And this is the point of my whole line of questioning here, which is the question that Mr. Yar asked you on line 16. If that guarantee, when we're talking about the 635 million, or that commitment were exercised, are you saying that the fund, Flagship 3, wouldn't own a piece of that transaction? Is that your testimony today, that if that guarantee is exercised, there would be no ownership transferred?
I think my testimony is probably inaccurate, not correct in that deposition statement, in the sense that if at the point in time that the equity commitment were made by Flagship 3, what that commitment actually provides is that Flagship 3 would acquire the equity of Saturn Utilities, LLC, to the extent of the amount of its commitment, so that the equity would be available as required by the purchase price.
Okay. So going back to your direct testimony, and thank you for that correction, because we were puzzled by that answer in the deposition. So thank you for clearing it up. But if you go back in your direct testimony to page 27, which is the org chart, the post-close org chart.
Yes, sir.
Could you clarify which, if that guarantee was exercised, and that fund that you identified, which is, let me get the name right, just so we're all on the same page, which is Flagship 3, they would get an equity interest in which one of those boxes, which one of those companies in that org chart?
Saturn Utilities Holdco, LLC.
The same one where you're employed and have duties.
That is correct.
And you would agree with me that that potential ownership is not reflected in this org chart. Would you agree with that?
That's correct, because we do not intend for those equity commitments to be carried out by either Fund 3 or Infra 1.
But you would agree with me, would you not, that they could be?
They will. We know that they will not at this point in time.
Was that, then I guess I'm further puzzled by your testimony on page 29 that money's available. Are we saying that that guarantee has lapsed, or where are we at with that guarantee?
No, it still is in place. However, there is sufficient funding from Infrastructure Fund 2. We now know that we have sufficient funding that we will be able to close that transaction, and we will assign those equity commitments from Flagship 3 and Flagship 1 to Fund 2. And we explained that I believe in some of our answers to the bench requests.
Can you give me a specific site to that so that we can close this line of questioning?
Yes,
To that bench request?
I'll have to.
Well, why don't we come back to it? Maybe take a break and
Okay.
at lunch, and we'll come back to it. Two final questions. One is, would you, if this transaction is approved and that guarantee is exercised and the ownership changes, would you agree that you would need to update this org chart to show a different fund being an equity owner?
I would take exception to that because it would only that equity ownership would only exist for just very short periodic, a very quick period before it would be transferred back to the intended infrastructure fund 2. So it's not intended to be, nor was it ever intended to be a long-term holder of that asset. It's only making the commitment for the purpose of securing the transaction.
Okay, so we can move on then. I would like to now look at your testimony on page 18. And I'll try to be less laborious and see if we can't move through some of this information in more detail. I mean, in at a higher level, just to get this on the record. Lines 8 through 23 describe two transactions that have occurred where BCP infrastructure funds have acquired gas local distribution companies in Louisiana and Mississippi. Is that a fair general statement?
Yes, that's correct.
And you call the first, on the first bullet point on line 8, you call the first such transaction a center point transaction, which includes 4 entities by my count. Is that accurate?
That includes the center point transaction includes 3 utilities that comprise that acquisition.
I count, I have North Louisiana Gas Company, South Louisiana, and then Mississippi, but then I have something called Delta Energy Resources. What is that? It's in that, it's on line 10, I mean 11.
Oh, yeah, Delta Energy Resources is I need to double, let's see. Delta Energy Resources is not an operating utility. I think it existed to own certain pipeline assets. So it was part of the acquisition, but it's not a separate utility. So although you're right, it may have been an entity acquired as part of the sale. I guess I didn't think of it in that way, since the other 3 are actually the operating utility companies that were acquired.
Okay. And that deal closed on April 1st of this year.
Yes, sir, it did.
5 or 6 months ago. And then the second bunch of transactions is called Entergy. And that has 3, has a Delta Capital Gas Company, Delta, is it Now or New Orleans Gas Company? That second one.
That's a typo. It should be
Yeah.
Delta New Orleans Gas Company.
I figured that. And then the last one is called well, there's just 2, right? There's Delta Capital and Delta New Orleans, right?
That's correct. And so Delta Capital would comprise the former Entergy Baton Rouge area, and Delta New Orleans would cover the former Entergy New Orleans utility.
Okay. And you're aware that we took the deposition of Mr. Tuminello in August? Peter Tuminello?
I am aware, yes, that you took Peter's deposition.
Did you listen in? Are you familiar with his testimony in that deposition?
I did not listen in, and I'm not specifically familiar with his testimony.
Well, to the extent you can answer the question, and I will be questioning Mr. Tuminello about this, but in that deposition, he stated that that BCP would need to integrate all of these newly acquired utilities into a single company under an umbrella called Delta Utilities. Is that your understanding as well?
That is incorrect.
Okay.
There is not one holding company. There is the Delta Utilities Services entity will serve as a shared service provider to both Magnolia and Delta, but they remain separate rate bases, separate regulatory jurisdictions, separate rate constructs, separate operating companies. So there's no, they're not being consolidated under a common holding company structure.
Mr. Baudier, right, that very next sentence on page 18, lines 24 and 25 says the LDCs acquired under the CenterPoint transaction and the Entergy transaction are operated under the umbrella name of Delta Utilities. That's your testimony?
Yes, so there generally we referred to these entities as Delta. And that was even sort of the original intent when we not to merge them at all or integrate them. We just, for simplicity, initially thought we were just calling them under the umbrella of Delta Utilities. However, due to sort of confusion with all these various entities being referred to as Delta, we actually now have renamed them. So the CenterPoint transaction, the operating companies are known as Magnolia Gas Company, and just the Entergy transaction are known as Delta Gas Company. But the shared services entity is known as Delta Utilities.
Thank you. Go ahead, Mr. Gould.
Well, thank you for that, Madam Hearing Examiner. That was exactly my question. The umbrella language had me maybe confused is too strong, but I had questions. Mr. I'm going to state what Mr. Tuminello said and tell me if you agree with my understanding. Mr. Tuminello said that from the July 1st date when the Entergy transaction was completed, it would take between 12 and 18 months to completely set up this Delta Utilities Service Company. Is that your understanding?
No, that's incorrect. Delta Utilities had been completely set up, and it actually completely took over the operation of the Entergy transaction on July 1st. It had been stood up in the 18 to 24 months prior to the close of the Entergy transaction.
So are those, there was, I guess, at some point, both Magnolia and Delta Gas Company, those groups of companies were getting shared services from their former parent companies, right?
That is correct.
Has that process of transitioning away from the parent companies been completed? Is that your testimony?
So in the Entergy transaction, and this is why it was completed in July, that's what we call a day one cutover. So on July 1st, everything completely went to Delta with no support from Entergy moving forward. On the Magnolia transaction, the CenterPoint transaction, we have a transition services agreement very similar to what we have with Ameritico in this transaction with New Mexico Gas for a much shorter period. But under that scenario, CenterPoint is continuing to provide shared services as we integrate the Magnolia shared service functions into Delta Utilities. As we move those over, and we expect that transition services agreement to, we hope it will end in April of 26, no later than June of 26.
So either the second quarter or the third quarter.
I hope by the end of the second quarter, I would say.
Okay. Thanks for that clarification. And again, and I'll go through this with Mr. Tuminello. I just want to make sure that I understand from a high level. Mr. Tuminello talked about that Delta Utilities shared services company. What's the proper name for that?
It's Delta Utilities. I believe it's Delta Utilities Services.
Okay.
Whether it's an LP or an LLC, I'm not positive off the top of my head.
He indicated in his deposition, and we'll visit that with Ms. that company was still being staffed up. And he was taking, what his description was, they were taking good people that they had identified from both Magnolia and Delta Gas Company and bringing them into this shared services company. Is that your understanding?
Madam Hearing Examiner, I need to object. We've had several questions now about what Mr. Tuminello supposedly said. And while, I don't mean to suggest that Mr. Gould, is intentionally stating things that Mr. Tuminello didn't say, I think it's only fair that Mr. Baudier be allowed to look at whatever it is Mr. Gould is referring to, or else ask his questions in a different way where it's not dependent on what Mr. Tuminello said, but simply what Mr. Baudier's testimony is on a given subject.
Madam Hearing Examiner, I did. All I'm doing is asking, what is his understanding of the current status of the transaction? And that I thought I made that clear. What is your understanding of the current status of the Delta Utility Service Company? Are they fully staffed up?
They're essentially fully staffed up, but for a couple positions here and there, so as a result of both of those transactions, in the acquisition, the buyer company acquired all of the existing employees of both companies. We call them traveled. So all the employees, there's some 800 employees that came from CenterPoint as well as from Entergy. And then there were, prior to July 1st, 200 employees stood up in the Delta Utilities service entity. And so that's complete, and that was complete before the Entergy deal, as was the transfer of those employees. So while there's still some services being provided from CenterPoint, there are no further employees that need to move from CenterPoint to the Magnolia entity. And in fact, all of the gas employees effectively now work at Magnolia, so they're actually providing it through a central shared services that is sort of the CenterPoint Electric company.
If you know, when was that Delta Services utility transition to a full standalone? When was that completed?
I would say it was, in my opinion, it was completed in order to accomplish the cutover, certainly by July of Entergy, but a number of functions had been testing and operating well before then. So I don't know if I had to, I would say it was certainly done by then. It's possible there's still some additional hires that are being made in that organization, but essentially the organization was complete to accomplish the Entergy cutover.
Okay. And then if if this transaction is approved, there's going to have to be a transition at gas company, at least for the IT services. Is that a fair statement?
Could you?
Well, let me ask
clarify
the
your
better question. Yeah. Your proposal, and we'll get into this in more detail, is to have this Delta Utility Service Company provide IT services at New Mexico Gas Company. Isn't that your proposal?
That's correct.
How long will that transition take place, if you know?
We don't know exactly. However, by the time this transaction closes, so if we assume this transaction would close, let's say first quarter of 26, we expect to be very close to the completion of the Magnolia integration, or I'd call it the transition away from the Magnolia TSA. We also have a TSA from Ameritico that will give us up to 24 months to complete the transition to the IT services for New Mexico Gas, although we do not expect it to take that long. So,
okay.
Well, I would expect it to be accomplished in the 12 months of the primary term of the transition services agreement.
Okay, and I'd have to apologize because I thought I had it here on the desk, but there is an exhibit in Mr. Tuminello's revised direct. It's exhibit PIT2. Can you turn to that, please?
I don't believe I have it. I'll have to.
Well, let me just ask, yeah, why don't you, after we take a break, maybe we can go to that, because that's my next line of questioning on some of those timelines.
Okay, I did find it, but is this what you're calling high-level transition plan?
Yes, exhibit PIT, which is Peter Tuminello 2, to his revised direct. Do you see that? It's a 17-page document.
I do see the document.
Okay. Would you look at page 16 of that document?
What was the page, sir?
Again, it is page 16 of 17. The exhibit is labeled JA Exhibit PIT -2 revised application.
I do see the document.
And could you look at page 16?
Yes, I'm looking at page 16.
This is the high level transition timeline that we were just talking about, right?
It looks like it is what I would call a Gantt chart demonstration of a timeline of the project.
And it at a high level, it intends to show how many months or at which point in the transition, certain events, high-level events occur. Is that a fair statement?
It does look like that's what it's doing, yes.
Okay. And I have a few more questions about this, and then I want to switch over to the IT proposal that you have. But the first question is, the start point is labeled at the top line of +1, right? Up there in that brown line. Do you see that? That
Yeah,
at the very top? And +1 is the date that you're anticipating that you would have a final order from the commission on this transaction, correct?
that is correct.
Okay. I wanted to return to that, but I have a whole line of questions about that. So I want to shift gears just a little bit so we can finish at noon and then pick up with my line of questions about this high-level chart after lunch. If the hearing examiner has a designated time that she wants to take a break. So what I want you to do is turn in that exhibit, that same exhibit, to page 5. Do you see that?
Talking about page 5 of the testimony?
Page 5 of 17. Yes, sir.
5 of
Was
17.
that? Yeah, that was Mr. Albedris for the benefit of the court reporter.
Yes, sir, I'm on page 5.
And you see that that block of text that has the tan coloring background on
Yes,
that
sir, I
exhibit?
do. Yes, sir.
Okay. Would you review that so that I can ask you a couple of questions about that block of text on the left side and then the point number 3 on the right side? Let me know when you're ready.
I'm sorry. Are you referring, Mr. Gould, to both of the blocks, both of the columns that are shaded?
Yes, I want the first one, the left one. I want you to read that to yourself. And
Yes, sir, I've read both of them, both of the boxes.
okay. My high level question is that the basic proposal for IT shared services from Delta Utility Services is that you would transform or transition New Mexico Gas Company from a server-based on-premises system to a cloud-based system. Is that accurate?
That's accurate, and I would add that it would transfer from an SAP system to an Oracle system.
Okay. And so therefore, and I think you've stated other places in your testimony, there's going to be a considerable transition cost to accomplish that. Is that accurate?
There will be a cost. We actually think the cost will be less than it will cost New Mexico Gas to have stayed on the SAP system that they're currently on.
Yeah, but the point, I guess, of my question is that the transition is from a premises-based, server-based system to an Oracle cloud system. Is my understanding fundamentally correct?
That's correct.
Okay. Madam Hearing Examiner, I don't know if I'm getting out of my lane here by suggesting if we could take a break now and come back at whatever time you would allow for lunch.
Do you have another question you can finish in 2 minutes?
Yeah, I do. I have one of those 2-minute questions. Let's see if I can find
Go
them.
ahead.
Okay. Do you have a place in your testimony, so I don't have to search for it, where you estimate the range of those transition costs?
Yes, sir.
I know I have it someplace, but
I have it, Mr. Gould, on page 67.
6.7 or 5.7?
6.7.
Okay, thank you. Okay, and we're looking at line 18 and 19. And I'll read this sentence. These allocated costs are in addition to the direct, oh no, excuse me, that's the wrong thing. 11 through 13. The total projected stand-up cost to migrate NMGC Oracle Fusion Cloud ERP and Oracle Work and Asset Cloud Service Platform is estimated to be in the range of 32.5 million to 44.86 million. Did I read that accurately?
Yes, you read it partially, but the part you read is accurate.
Okay.
There is a continuation that compares it to the, as I mentioned, the legacy SAP cost that NMGC would otherwise incur.
Okay. And those legacy costs are estimated to be $56 million as of the filing date of this testimony, which is July 1st of this year, right?
Yes, sir.
And when did you first?
July 3rd.
July 3rd, excuse me. I was confused with the closure date of the Entergy transaction. When did BCP come up with its proposal to migrate New Mexico Gas Company over to the Oracle Cloud platform?
It was sometime following the initial application. I would say this, I know it was before the date you took my first deposition because we discussed it in my first deposition. So sometime within that time period, if that's helpful.
Yes, and I think that first deposition was on April 14th. So in the April 2025 timeframe.
It would have been probably prior to that. It came up in the deposition, but exactly how soon after the application filing or how soon or how much in time prior to that deposition, I can't pinpoint an exact date today for you.
Okay. And just to go back and one last question on this particular subject, the range of 32.5 million to 44.86 million is based upon a migration of New Mexico Gas Company from a server-based SAP system for IT to a cloud-based IT system that's provided by Oracle.
Generally speaking, yes.
And the $10 million savings between the 44.86 million or $11 million savings and the $56 million that New Mexico Gas Company would otherwise incur is also based upon the assumption that the gas company would stay with a server-based SAP system.
I would have to say yes, that it would proceed with its planned upgrade of the SAP system.
Okay. And Madam Hearing Examiner, those are my 2 or 3 questions. And if I could take a break now, and then we could kind of start in a new direction after lunch.
Well, let me ask you, there's more to that testimony, Mr. Baudier. Something about transition costs would also be included, or would be in addition to that range of 32.5 to 44.86. Isn't that correct?
Yes, Madam Hearing Officer. What this is referring to is a particular element of the transition cost that we have not totally estimated or pinned down yet, but this relates to whether or not there would need to be any allocation of capital spent by Delta that for the capital they've already spent to stand up their system, the IT system, whether any of that would have to be allocated to New Mexico Gas Company to the extent that capital investment benefits New Mexico Gas Company.
Do you have any idea how much more?
We do not know that yet, and we do not know whether or not such an allocation would be required, or at least be required to be paid for by the New Mexico Gas customers.
But if there is an additional cost, that would cut back on your estimation of savings, wouldn't it?
If there is, assuming that the 56 million is accurate as well.
Okay, very well.
You are correct.
All right, sir, thank you. Let me stop Mr. Gould's clock here. Mr. Gould, you are at 120.
Okay.
Of your 5.
Okay.
Let me stop. Let me stop the share, and I see Ms. Beatles' hand is up. Ms. Beatles?
I have a noon appointment that may spill over past 1, so I request to be excused, subject to any rulings in my absence until I return, which should be no later than 1:30 or 2.
Okay, thank you. Appreciate that. In an effort to try to make up some time, because I don't know that Mr. Gould's going to give me back any time from his 5. So in an effort to do that, let's come back at 1, and we'll begin with our test. Continue with the cross from Mr. Gould. Again, I just let you know, don't forget about the YouTube if you're going to leave your computers on. So we are recessed until 1 o'clock. Thank you.
Mr. Gould, can you hear me?
Loud and clear.
Thank you, sir. I can hear you too.
And how have you been, David? Busy?
Good, you? Oh, yes, sir.
I tell you, I've been, I am so happy this hearing we're finally doing it. Okay. Anyway.
How are we doing, Mr. Lee?
Good, Judge. I'm ready to go.
All right, let's go back on the record then. We're back from our lunch and recess. And I believe you have a little more cross-examination, Mr. Gould.
Yes, Madam Hearing Examiner, and the time that has elapsed, you stated as 120, you meant 120 minutes, right? 2 hours versus 1 hour and 20 minutes?
I meant 1 hour and 20 minutes.
Oh, okay.
So see, that's even better for you. I should have said, no, it's 1 hour and 20 minutes.
You should have said you have 2 hours left. There's that great scene in that movie, of that television show Justified, where he's telling the guy he has 25 hours to leave town. Then he says, now you got 20 minutes. Now you have 2. And then he shoots him. So I figure you're going to shoot me.
No, too violent. Okay, your time is running, Mr. Gould.
My time is running.
Peter, could you ask that question again? Maybe the hearing examiner has a different answer this time.
You know, I don't want to see everybody start to put party hats on. Mr. Baudier, and I just want to circle back to the discussion that we were having right before lunch, and you gave a couple of answers around these transition costs that related to the IT migration. And I just wanted to start there as to anchor this next set of questions. If you could go back to page 67 of your direct testimony.
Yes, sir, I have it.
Okay, and it's the Q&A that starts on line 8 and goes down to 19. I think you just put on your mute. Okay, there you go.
Yes, sir, I do have that.
Okay, so basically we were talking about 2 buckets of costs. There's the 32.5 million to 44.86 million, which is the specific cost that has been estimated to migrate New Mexico Gas Company from its current server-based SAP to a Oracle Fusion Cloud. And then you have lots of other names there, but that's one big bucket, right? Or that's one
Yes, sir,
bucket.
that's one bucket.
I won't characterize it big or small. And then there's another bucket, which would be costs that are internal to the Delta Utility Services Company that it incurred to set up
Sarah
the
Hold on
Oracle.
just a second. Just a second, Mr. Gould. Anybody not talking should probably want to mute their audio. We're picking up feedback. Go ahead, sir.
So the second bucket of costs are, and I'll read that so I don't mischaracterize them. Additionally, joint applicants expect that some element of the transition costs will include proper allocation of transition costs incurred by Delta Utilities that directly benefit the NMGC stand-up. Did I read that correctly?
Yes, sir.
And you told the hearing examiner that at present you did not know what the total of those costs might be.
That is correct.
Okay. Are those costs, how are they different from the IT costs that we talked about before, the range?
So I may not be as artful as Mr. Tuminello or Mr. Miko in answering these questions because they know a lot more about the details. But what I would say is that there are costs that are going to have to be incurred to, say, replicate the Oracle system. And then that system will be placed at New Mexico. So there are going to be parts of it that will sit, here in New Mexico, that function in New Mexico. And so there's some costs that will have to be incurred with regard to that. And so that's, in my mind, kind of how I think of that bucket. Although, and then I think of the second bucket as you described it, which is costs that were already incurred by the Delta utility in its stand-up, but that some part of that system will be benefiting New Mexico.
Okay.
And so I would agree. But I'd say that, well, I don't want to, there's a third category of cost, but maybe I'm jumping ahead.
No, go ahead. I'd like you to finish your answer, and this seems like a good time to do it.
So if you continue reading on page 67 going into 68, there's the ongoing operational costs of the system.
Yes.
So those wouldn't be a transition cost, right? They wouldn't be like a CapEx type of transition cost, but they would be as I discuss it in that testimony, it's basically the ongoing annual operating costs that will relate to the Oracle Cloud components of the new system, shared IT support, cybersecurity operations, software maintenance, and that our estimations tell us that that will be cheaper on an ongoing basis than it has been to maintain the SAP system on an annual basis. So that's a third bucket of costs.
And those would be rolled into the cost of service for gas company in a future rate case, those ongoing costs, just as a part of the normal expenses of running the IT system. Is that your understanding?
Yes, sir.
Okay. And I know in your testimony, if we need to refer to it, but I think we can just ask a couple of questions. You have stated that the BCP applicants have withdrawn their request to establish a regulatory asset for that bucket that is the 35 to 44.86. Is that accurate?
Yes, that's correct.
However, and tell me if you disagree with this statement and this question, you are still reserving the right or the ability in a future rate case to ask for those costs, those 32 to 44, in a future rate case, if you can show they're used and useful.
Yes, that's correct.
Okay. And the same thing with those Delta internal stand-up costs. You would reserve the right or the ability to ask for those in a future rate case on the basis that they're used and useful in providing customers with service. Is that a fair statement?
Yes, sir, that's correct.
Okay. I know that we disagree on whether or not on the issue of whether the two prior acquisitions and the terms and conditions are precedential to this acquisition. I don't want to argue with you about that, but I did want to ask you, were you aware that in both the TECO and the Emera cases, the applicants voluntarily waived any recovery of any transition costs in a future rate case?
I actually understood to the contrary, because when I read the order from the case, I saw that they, very much like we're doing, have wording in that final order that says they would have the right to seek recovery of those costs in a future rate case.
Well, I'm referring to, and if you could find that site, I'd appreciate it. But if you would turn to the case 13-00231, certification of stipulation on page 28. And we have provided that in our list of exhibits, if it's easier to go there, as exhibit number 43, NMary exhibit 43.
Yes, sir. I'm on page 28.
If you would look under B, the costs of
Hang
a
on,
transit.
wait,
I'm sorry.
hang on.
Pardon me.
Because I thought the whole reason that you wanted to give your assistant access was to get into the Dropbox.
Well, I think, yeah, these are some pretty,
But
these are a
so
couple of simple questions on this certification. So I think we can do it without her.
well, I want to get to the Dropbox because
Okay, I'm
I
sorry.
have an issue, Mr. Gould, with the fact that you're asking people to look at the certification and not the final order in the case. Because some of those certifications have errata and some of the final orders do not accept all of the certifications. So, I mean, if you want to put that disclaimer in, that's one thing. But it, seems like to me we would want to be looking at the commission's final order in the case and not don't know why it's not letting me get to Dropbox.
Okay. I anticipated that, and if we need to set that up as a foundation question, I'm certainly able to do that.
Go ahead while I'm
Okay.
looking.
Okay, Mr. Baudier, have you reviewed the certification of stipulation in case 13-00231, which was issued on June 30th of 2014?
I viewed it many months back in the past, and I'm viewing it right now as you presented page 28 to me.
Okay, and if you believe that I've misstated anything about in these questions that follow, anything about that certification, would you please note that in your answer?
Yes, sir.
Okay, and then that particular certification of stipulation, I only included the certification in our exhibit, but there was a final order of the commission on August 14th, 2014. Would you accept that subject to check?
Yes, sir. I'll accept that.
And on the last page, on page 10 of that final order, and again, if you could accept this subject to check, the decretal ordering paragraph of that final order states the decretal paragraphs contained in the certification of stipulation as set forth in Exhibit 1. So the certification was attached to that final order as Exhibit 1, are incorporated by reference as fully set forth herein and are adopted, approved, accepted as orders of the commission. And then it goes down on ordering paragraph C. It says all the exceptions are denied. So the basis for my question, and if you disagree, please let me know. And if your attorney wants to chime in, let me know that the words in the certification of the stipulation were fully adopted by the commission. Okay, that's my assumption.
Going to object is calling for a speculation and lack of foundation for this witness.
Okay. Okay.
Mr. Gould?
I don't think, if he thinks that reading the words of the commission order is speculation, he can tell me that. I'm just going to read the words and ask to see if he understands them and what he understands. He's fully free to say what his opinion is.
Your Honor, that doesn't cure it. We need to see the full final order if we're going to be asking questions about the full final order.
Right, I agree with you.
Well, I was told in the pre-hearing conference that we didn't need to put these things on the record, that commission orders, everybody would be expected to know them. And these are clearly commission orders that are directly relevant to this case. If I just uploaded the certification just for the ease of questioning, but we can scan and upload later this afternoon the final orders in both of these cases. But I don't think I'm misrepresenting what he said. And these are cases that the attorney should be fully conversant with.
And Your Honor, that's not the issue about whether the attorneys are, it's whether this witness who's on the witness stand is. And we didn't say that witnesses would be fully briefed on the orders or the stipulations. We said, we'll have them available. But
1321, Mr. Gould.
Yeah, let me
I've got it.
Yeah. 13, just for the record, 13-00231. And the final order is dated August 14th, 2014. And what I was reading from was page 10, which is the last page before the signature blocks of the commissioners.
Mr. Bodier, if you'd like to look, the screen should be shared at this point.
Yes, Madam Hearing Officer.
Let me move it. Let me move over to show you. No, that's his. Where's mine? Mm-hmm. Well, too many screens. Let's see if I can get it here. Nope. That's because it's my Dropbox screen share. Okay, hang on. Stop it. Okay, come back. It won't let me get it. Can't get it off my Zoom screen. Well, nope. Can't help you out. Thought I could, Mr. Gould. It's not letting me
Maybe
pull it up.
after the break, we might be able to get it and we could.
Well,
Okay.
let's just move on at this time. So we've just covered the issue on page 67. What I'd like to do is to have you, do you have access, Mr. Baudier, to our Anameria exhibit lists and the documents that are included there in the Dropbox?
Believe they can provide me with any exhibit
Okay.
of any party.
I want to have you look at what's been marked for identification as Anameria hearing exhibit, and I added the hearing, but Anameria exhibit number 29. And it's just described as updates for SAP ERP.
Yes, she's finding that for me right now. If you
Okay.
could wait 1 second.
I certainly could.
Yes, sir, I have it.
Okay. And I understand this is not your document. This has not been either provided by you or prepared by you, and that you cannot affirm the truth of any statement that's claimed in this document. But I do want to ask you a high level question after you've had a chance to review it.
Your Honor, I object to having a witness look at a fresh document he's never seen and then opine on it.
I'm not asking for an opinion. I'm just asking.
Or you're going to ask him to testify about this document. It hasn't been admitted into evidence. And
what is it?
It is, Madam Hearing Examiner, a download from the SAP website, and I won't describe it any further until we get into the document.
It's fine. Yeah, same
Well,
objection.
let me.
You can look at,
let him look at the document, and then let's see what the question posed is.
I have read through the document, which yet appears to be an advertisement of some sort or a marketing document from SAP.
Okay. And if it wouldn't be too much of an opinion, you would agree that on the first page it's dated August 4th of 2025?
That is correct.
Here is my general question. This document purports to announce a SAP cloud-based IT ERP edition, and it invites current SAP customers to migrate to this option. Were you aware, or had you become aware that SAP was
according to who?
I'm just talking about the document itself.
Right, but you can't testify about the document. So
okay. Well, let me ask this question. Are you have you become aware whether or not SAP has announced a cloud-based IT system?
I was not aware. It does not surprise me at all, but I was not aware.
Okay. Would there be any of your witnesses that deal directly with the IT issues that might be aware of whether or not what this document purports to say is true or not?
I apologize for interrupting. Yes, Mr. Miko would be an expert on this and
Okay.
would be very, very qualified. And to a good degree, Mr. Tuminello as well, but certainly Mr. Miko. He's integrated both types of Oracle and SAP systems.
Okay. So I can save my questions for him and we'll just go forward from there. So Madam Hearing Examiner, we are not seeking the admission of this document at this time. So I think we can move on from there. Would you, changing gears, would you, I want you to look at two things, Mr. Baudier. I want you to go in your direct testimony. No, excuse me. I'm sorry. In your rebuttal testimony for the revised application to page 48. And I'm looking at this table that the hearing examiner mentioned earlier, JA table JMB-2.
Yes, I have it.
Okay, and then the other document that I want to refer to in this line of questioning is the Tuminello exhibit that we were looking at earlier. It's to his direct testimony. It's exhibit PIT for Peter I. Tuminello 2. And it's that high level transition timeline that we spoke of before lunch.
That's it. And are you on page 16?
I am on page 16, 1-6. Yeah.
Okay. Yeah, I can see that.
Okay. So going back to your table and your rebuttal, you're claiming a monetary benefits to customers of up to 40 million for what you call rate case delay. Do you see that?
Yes.
And that benefit is based upon the commitment that the joint applicants have made not to file a rate case until September, I guess the end of September of 2026, right?
Not before then, correct.
Right. And you're claiming that that delay from where we are currently in the case schedule, that delay is worth $40 million maximum, right?
Correct.
So what I want to do is test the assumptions that underlie that claim. So that's why I wanted to have Mr. Tuminello's time chart. If you would look at that time chart, I see at the top you have like negative months and plus months. And that line item at the top, it's not numbered, but
Yes, I see that.
okay. What does +1 mean?
As I'm interpreting it, it is months going forward from that point in time. Whereas to the left side, if you're thinking of like integers, those are months preceding that point in time.
And I noticed that there are no calendar dates on that exhibit, right?
That's correct.
Okay. And +1, the beginning of +1 is the beginning of the month or the beginning of the time when this transaction would be approved by the commission, right?
That's correct. Could I possibly clarify my last answer?
Please do. Yeah.
When I look at the bottom of the chart with those sort of, I don't know, purplish dark blue lines,
Yeah.
I see that there are some references to Entergy cut over to Oracle Q325. And then if you look further down, it says CNP, which would be Centerpoint, cut over to Oracle Q226. So to that extent, there are some indications of dates. Assuming those dates line up vertically along the chart, then it would look like that would kind of set the time frame.
Okay. And I notice on the top line, you're exactly right to point it out, right below the negative months, there is a notation, joint application filed July 3rd, 2025. So that refers to the revised application in this case.
Okay, that makes sense.
Yeah, okay. I get my first question is a simple one. In order to determine what this delay in the rate case really means for customers, what date are you anticipating as we sit here today that you will have a final order in this case? Either approving or let's just assume that if you anticipate a final order approving this acquisition, when do you expect that to occur?
I don't know for certain, to be honest, because I don't believe, to my knowledge, that there are any deadlines for the PRC to reach its final conclusion. And obviously that has to be following this hearing. And so I think being very hopeful that it would be the late first quarter or second quarter of next year, that would be certainly any time in the first quarter of next year would be very good.
Okay. Have you sat down with Mr. Shell or with, and I'm not asking you to reveal any confidential information that you receive from your attorneys, but have you talked to knowledgeable regulatory people in your sphere to determine what would be a reasonable time after conclusion of a hearing to have a final order in a complex case like this?
Again, I don't think I've gotten anything with any certainty, although for some reason I have in my mind that maybe 6 to 8 weeks following the issuance of the recommendation from the hearing officer might be a typical timeline.
Okay. And do you have any, and again, if you don't know, it's perfectly fine, but do you have any understanding of how long it would take to brief this case after the hearing, and then how long after that it would take to get a recommended decision?
Yeah, I do not, but I recognize that, we have holidays and everything else. So it's difficult to tell in the time period that we're in.
Okay. And just to make clear where I'm going, because I'm not trying to sandbag you on this, but would you agree that the later in time that a final decision comes from this commission on this case approving this transaction, if that's what they want to do, the more meaningless that rate delay becomes, right?
I'm not sure I understand your logic.
Well, let me see if I can explain it, and we can have disagreements if we can. Gas Company of New Mexico Gas Company would not begin to prepare a rate case filing, would it, unless it knew the outcome of this case. Would that be a fair statement?
I don't know if that's fair or not. What we know is that the normal cadence for the rate case for New Mexico Gas would have had it being filed this past September.
And as we sit here today, this case would have been ongoing when that rate case was filed, right?
Once assuming that it had been, delayed as it has been, yes.
Yeah, under the current circumstances, if you had filed it in September, we'd be still in the middle of this case, correct?
Yeah, I mean, that is true. That's how the timeline worked out, yes.
And do you have any opinion on how a rate case filing in the midst of this complicated case would have been received by the parties, if you know or can guess?
Objection calls for speculation.
Yeah.
It does.
Well, let me ask a better question. From your perspective, as BCP, would you have advised NMGC to file a rate case this past September, given the difficulty of this current proceeding?
Well, we're not in a position to advise New Mexico Gas as to what would have been the best course of action from our perspective. Both because BCP at the time was not in a position to, direct the company in that sort of way. Certainly, we couldn't have advised or given them guidance as to when to file the rate case. Our concern just remains around the inability to, whenever you have a rate case delay or you get out of your cadence or a rate case stay out, you create essentially a danger that you're delaying your capital plan. So, at some point, the question would have been, what would be, reasonable so that you don't put the company in jeopardy by delaying the rate case for too long. But we never felt ourselves being in a position of directing or advising New Mexico Gas Company as to when it should file the rate case.
Okay, maybe I can ask the question in a better way. From BCP's perspective, would you have welcomed, and I'm not talking about advising gas company or opining on their recovery or their capital costs, would you have thought it would have been a positive development from BCP's perspective for New Mexico Gas Company to file a general rate case this past September?
I think it's difficult to answer that because I don't know based upon what parameters you're looking at. Certainly, if they would have had the proper information and felt prepared to file it, then yes, we would have encouraged that. If for some reason the filing would have been deficient for some reason or something, we would not expect them to do something that did not seem prudent.
So you don't think that having these same stakeholders and the commission have to spend their regulatory resources litigating two gas company cases at the same time would have been a detriment to getting approval of this transaction?
That could be a consideration, but again, it's just speculation. I don't know that, and I don't know enough about the the history of how the matters have been handled in New Mexico. So and I don't know. I also don't know whether or not an isolated rate case couldn't have happened. That because I don't see the stay out and these transition costs. I don't see the savings from the stay out and these transition costs as related.
Okay. Yeah, and that wasn't my question. I'm just asking the question that I asked. So let's move on. You had indicated that you're generally, but not intimately aware of the timing of final orders and recommended decisions. But I wanted to ask you a couple of questions in that general area. And if you can't answer, please let me know. Is it your opinion that, or do you have an opinion? Do you understand whether gas company in its next case would file a historical test year or would use a future test year? Do you know?
My understanding is it will be a forward test year, a future
Okay.
test year.
And have you had experience with future test years in other jurisdictions or with other companies?
Very limited. I've learned a bit. I've learned about them as I've done the due diligence on New Mexico Gas Company.
Okay. Do you have an understanding of everything that would, not everything, but the general parameters of what gas company would need to prepare in terms of data to file a future test year case?
Not very, it would have to be very highly general, but I'm
Sure,
assuming,
go ahead.
Again, and I may have, maybe I'm misspeaking, but if you were to file a rate case at the end of 26, I believe my understanding, your test year would be sometime in the middle of 27 into 28.
Yeah, and I'll make a statement and see if you agree that this comports with your understanding that under the generally accepted principles here in New Mexico, a future test year sets the rates on the first day, sets the rates based on the costs and expenses on the first day the rates are expected to be in effect. Is that
Right.
your general understanding?
That makes sense, yes.
Okay. Have you had any conversations that you can share with gas company about what it would take to prepare a future test year rate case? How much time?
Not in any detail, although I expect it would be extensive.
Would 5 months of preparation be consistent with your understanding of how long it would take?
I really have no idea. I'd
Okay.
have to rely on Mr. Schill and
Okay.
the rest of his staff.
Okay, we'll move these questions to him. So if for the sake of this of this line of questioning, if you got just so we can set a date, um, if April 1st the commission issued a final order in this case approving this transaction, if you could assume that for the basis of my question, okay?
Okay.
Would BCP want to wait another 30 days so that the time for appealing that case, appealing that decision had run?
I really do not know. We'd have to rely on the advice of the attorneys in the context of the order.
Okay. But so maybe I could just understand, and I kind of made a compound question. You understand that after a commission issues a final order, parties have 30 days in which to appeal it to a higher court. Do you understand that?
Yes, I do.
And do you also understand, and maybe it's true in other jurisdictions, that they also, short of filing an appeal, can ask for rehearing of it, if you know?
I did not know, but that makes sense.
Okay, so that again may delay the start of when gas company would begin to prepare a rate case. Would that be a fair statement?
I don't think so, because the preparation of a rate case is not a matter that involves any extensive risk. You could certainly begin preparing the rate case without the transaction closing. So I don't agree that that would necessarily delay the preparation of a rate case.
Fair enough. So let's assume that you got a final order on April 1st approving the transaction. The 5 months between April 1st would put us into August, right? if it took 5 months to prepare a future rate case, right?
September would be 5 months.
September. So essentially it would be the soonest, if my assumptions in the question are correct, the soonest that gas company could file a rate case would be September under my assumptions, right?
Under your assumptions, correct.
Okay, let's move on. The initial, I want to talk about the shared services, if I could, that are being proposed. And if, again, if these are better questions for Mr. Tuminello or Mr. Miko, I can certainly, we have reserved time for them. The, what, let's just start at ground zero. What is the total expected savings on an annual basis for gas company moving away from its SAP server system to the Oracle system? Is that the $1.2 million that that you talk about in your testimony on page, I think it's 67?
On page, 67 and 68, there's an estimated annual savings of 1.2 million per year.
Okay.
And I don't know if I wouldn't say that's total. I would say that it's representing those components that are described on the beginning on page 7. So it's the savings that relate to Oracle Cloud subscription fees, shared IT support, cybersecurity operations, and software maintenance. So just for those items, the saving would be 1.2 per year is projected.
Okay. Would gas company need to hire any additional employees in order to run that Oracle system?
They may have one or two folks in New Mexico, you know, maybe one or two is too limited, but I don't think it's anywhere close to, you know, 8 or 9, but certainly between Mr. Miko and Mr. Tuminello, they can give you a better answer. But my understanding is there'll only be a couple people to cover the IT, like on the ground functions here, as additional employees, purely from an IT standpoint, but they can answer that better.
So the proposal, if I understand it correctly, is that all of the people that will be needed to run the Oracle system for gas company after we get through the stand-up period will all be at Delta Utilities Services Company, with the exception of 1 or 2.
That's my general understanding. I don't know if that is exactly correct. As I mentioned, they can answer that better, but my understanding is that the savings includes the personnel that would be necessary.
Okay. And then those would be the only shared services, all in your understanding, all the rest of the shared services that are currently provided by the Amira and Tico folks would be brought in-house to gas company, right?
Yes, other than IT, correct.
And I believe, if you know, Mr. Erickson has estimated that would require about 21 additional full-time employees.
I believe that's correct, yes.
Do you know what the total cost of those 21 additional employees would be? What it estimated? Go ahead.
I'm sorry, didn't mean to interrupt. We have seen reports on those costs. They're included within the operating cost summaries that support Mr. Miko and Mr. Tuminello's testimony.
And would those costs be included in your calculation of the $1.2 million savings?
That is my understanding, yes.
Okay. But as we sit here today, you're not exactly sure what the total would be on an annual basis.
As I said, it looks like they're estimating 6.6 million per year compared to 7.8 million per year that NMGC currently pays.
Okay. And I can get into that with Mr. Tumanello. I want to explore a little bit. You've testified, I don't have the exact site in your testimony, but you've recognized that the commission uses a 6-factor test to determine whether or not this transaction is in the public interest.
Yes, I do recognize that. It's in my testimony at page 38.
Okay. And you understand that the commission used those same factors in both the TICO and the Amira transaction.
To the best of my knowledge, that's my understanding, yes.
Okay, but it's your position today that this transaction should not be the level of benefits and commitments in this transaction should not be compared to the level of benefits and commitments in the prior transactions.
Correct.
What is the basis of that opinion?
Because that's not part of the test.
You don't believe the commission established the final orders in those prior cases as precedential?
I don't believe that the measure of benefits establishes a benchmark to determine whether another case in the future meets the 6-point test, because it's not measured against the time at which the prior benefits were provided. Those were provided and they were great and they delivered those benefits. Now we're back to steady state operation of the utility with the benefits that are being delivered to the customers. And the comparison is from this current status quo to the transaction in front of us.
Were you aware that in case 13-00231, the shared services were the testimony was that the shared services by 2018 would save New Mexico Gas Company customers about $9 million?
I'm not sure I'm not sure what the number is that you're referring to. I'm assuming it's one of the prior actions, but
yeah,
I don't know the document.
Yeah, I'm referring to the TICO final order and the certification of stipulation. And
I'd have to look at it.
okay, but are you aware of, do you have an idea in your mind today of the level of savings that were promised by the applicants in the TICO case to the commission as a result of the shared services? Do you know?
My understanding was that there was such a representation and that there was the elimination of approximately 100 jobs to match up with the transfer of those shared services.
Okay. So even though you don't believe that the prior cases should dictate what the commitments are in this case, do you believe that it's important for the commission to compare the existing benefits that they have received from Amira's ownership to the benefits that you're claiming.
That's precisely what we're doing in our application.
Okay. And so you would think so taking your answer at face value, that if the commission found that it was receiving more benefits by continued ownership by Amira, then they should basically deny your transaction, your proposal.
No, number one, we've demonstrated that there's not greater benefits by continuing with Amera. We've demonstrated that the shared service approach we're taking is actually going to be more affordable than is currently being provided by Amera. So my point is that we are actually demonstrating that we do provide greater benefit through the transaction.
Yeah, and I understand that, and I understand that you believe that in good faith, and my client have challenged that. I'm asking a more theoretical question. If you can answer it, please do. If you can't, then we'll move on. But if the commission, when it looks at this entire record, determines that you're wrong and that the benefits don't exceed the benefits that are provided by continuing ownership by Amira, in that circumstance, this application should be denied, right?
Based upon your hypothetical, if the commission determines that this transaction does not satisfy the 6-factor test, then it should deny the transaction.
So you do believe, and I think I'm kind of replowing the same ground, but you do believe that the 6-factor test, that part of the prior orders, is precedential and binding on this transaction.
I would disagree only to the extent that the precedential value is not in the test. A precedent is the decision made by a prior body. The test is a test. The test is like the legislation. It exists all the time. The test is applied to every circumstance. It is the binding rule, so to speak. So that's different from precedent.
Okay. I wanted to go back to your rebuttal testimony and go to that table on page 48.
I'm there. I'm sorry, I'm there.
Well, when we had, you had a conversation with the hearing examiner earlier today, you indicated that there were some additional benefits that you were offering that weren't encapsulated in that table. So this is what we call in the law a freebie. So would you tell us what is missing from that table? I know you guys are going to give us a new table, but as we sit here today, can you give us your summary of what's missing from this table?
Yes, subject to confirmation from the folks that are preparing the list. Let's see, the rate credits are in here. The economic development is in here. So on page 35, we agree.
And this is in your rebuttal or in your direct?
I'm sorry, my rebuttal.
Okay.
On page 35, we agree that if the parties desire to apply the 5-year CapEx plan as the threshold or the determinant for future CapEx payments, we said that we would be acceptable with that.
That's line 16 through 17.
Let's see, I'm actually speaking. I didn't have myself on the page, but I've got it right here. Yes, so line 17 and 18.
Okay.
This latter proposal, a commitment to maintain NMGC's current 5-year capital investment plan, is acceptable to the joint applicants.
Okay.
So that's an additional. The other one you've actually commented on, Mr. Gould, on page 37. We withdrew the request for a regulatory asset
Okay.
on the transition cost.
And that starts at the bottom of page 36. Sorry, I'm interrupting you. Line 17 and goes to the top of page 37, right?
Yes, sir, that's correct.
Okay. Okay.
And then on page 38, we agree to provide as part of the ring fencing commitments a non-consolidation of opinion consistent with what was done in the El Paso Electric case.
Okay. I had a question. Okay, if we could stop there. I had a question about the ring fencing, because would you turn to page 107 of your direct, please? And I'm looking at, I'll let you get there. This is part of the bench request response.
Okay, I'm on page 107.
If you look at the Q&A starting on line 16 down to line 23, I have a question about a figure that you have in that statement.
I'm sorry, are you referring to page 107, line 23?
16 to 22.
Oh. I'm not sure if this is not confidential.
Well, that's what we had. That's why I wanted to highlight it. And if it is, maybe what we need to do is have a confab with the hearing examiner on this, because this is, this relates back to a conversation we had earlier that we didn't delve into because of confidential concerns.
If
do
we
you want to go
disclosed it,
offline? Do you want to go take a 5-minute break and talk to your counsel? I don't want to.
I think we're fine. If we disclosed it, it's fine. We could talk about it.
Okay. I just don't want to transgress.
If you probe, there may be some details. If you probe further, that may become confidential, but the 2%, if we disclosed it, that's fine.
Okay. So you had mentioned in prior cross-examination this morning that some of the individuals in that BCP management company, I don't have the total name, but let me get it right just so, hold on. BCP Management LP, right? Would hold
BCP Management GPLP.
GPLP, sorry about that. Would have an ownership interest in some of the entities underneath them or down the line in that org chart, right?
Yes, in the fund and indirectly, yes, in those entities, correct.
And the company that this 2%, and it's a total 2%, it's not one individual.
So it's what we call the GP commit, and it means under it's very common in the private equity world. It means the general partner must commit 2% of the total fund value, so that we call that skin in the game, so that the general partner is also investing their own money alongside the limited partners, and so it's 2% of the ultimate value of the full fund, which is anticipated to be $2 billion.
Would that ownership in the Saturn Utilities Holdco LLC by folks up in the top of the structure, would that potentially destroy the ring fencing provisions?
No, absolutely not.
Well, if there were some sort of catastrophic event at gas company, couldn't the whatever liabilities manifested, couldn't the holders of those liabilities pierce the corporate veil of Saturn Utilities, because they could say there's folks at the top that are also owners and we want to go against their assets too, because there's not enough to satisfy the claims down lower in the chain of command. Isn't that a possibility?
No, it's not.
Why not?
Because the ring fencing works both ways, and so there is no connexity to the ownership of the intermediary companies above Saturn Holdco that creates any liability down below to the operating company.
I'm thinking I'm not thinking the liability flowing downward. I'm thinking about the liability flowing upward. And God forbid, we've seen catastrophic events happen with utilities. 4 or 5 years ago, there was a huge liability of a gas company in California. Could that kind of liability trigger a claim that would allow a claimant to pierce the corporate veil at that Saturn Utilities Holdco level?
No.
Again, I don't understand why. If they could say, not only is Saturn Holdco liable, but these individuals that have this 2% ownership, they are also part of the liability. And we're going to just pierce that, and we're going to go straight to their assets and have access to them. Why wouldn't that be possible in your mind?
Because they're separate corporate entities, and they're separated through those corporate entities. So the liabilities would not pass as a legal matter. You may disagree with me as a legal matter, but that would be for expert lawyers to opine.
One more question. I guess the problem I'm having with the answer is that the 2% owners aren't they're individuals. They are people. They're not protected by that corporate veil, are they?
They're limited partners of a limited partnership. And so they're members of a partnership. They're still part of an entity. They're not acting in their individual capacity. We're acting as limited partners.
Okay. Well, we'll if we want to pursue it, we'll save it for the brief. Okay. But I just worried about that, and I just wanted to confirm that 2%, and you can confirm as we sit here today that the 2% on 107 is not a confidential communication that we have to worry about.
Now, I will tell you this, and I probably shouldn't elaborate, but obviously we have exposure to not getting our money back, right? So if the business doesn't perform, we will lose our investment, and we will lose the money that we had to contribute as limited partners. So if the business were to fail in a way that maybe a claimant against NMGC might not be able to sue us, but if NMGC fails as a business, we will lose all of our money we invested.
Which is what you were calling skin in the game.
Exactly.
And the purpose is to motivate you through that ownership interest to operate in a careful manner, essentially.
Absolutely. To make the business successful.
Okay. I want to kind of change gears and go into a slightly different area. We have, go ahead.
We were in the middle of sort of summarizing the additional non monetary benefits. Did you want to complete that, or?
Well, that would, let me just see if there's, oh yeah, I interrupted you. I went off on a bunny trail. Are there additional benefits that you want to add to that chart in your rebuttal?
The only one I'm thinking of now is, and I'd have to find the page in the testimony, but we agreed to extend the employee retention benefit. I think we went from 36 months to 60 months.
Okay.
Because that was requested by one of the interveners, but I'm trying to find it in my testimony right now.
Okay, go take your time.
Let's see. It's like
Page 31.
that's where I was going, Your Honor.
Thank you, Ms. Nanasi.
Oh, I'm sorry. I was looking down. Yes, page 31, starting at line 8, where it asks the question, are the joint applicants proposing any additional employee protections? And we say that staff had proposed employee protections be extended to 60 months. The joint applicants agree to maintain NMGC's current level of employees as well as the 20 new jobs for 60 months following the closing of the transaction instead of the 36 months in the revised application.
Okay. Does that complete your answer with respect to the added benefits that you're proposing?
I believe the others are captured in the table.
Okay.
However, we are preparing that list, and that will be
Okay.
it may be more correct than what I just told you.
I want to kind of change gears and ask about your role, if any, in the actual operation and management of Gas Company of New Mexico. Okay. And
Okay.
we've asked some discovery about that, but I don't, I think we can kind of just ask you some direct questions and get the information that way. So that's what I intend to do. Are you, my question, my basic overall question, are you as Jeffrey Baudier, going to be actively involved in the operations of New Mexico Gas Company?
No, I will not.
What role, if any, would you have in a circumstance where gas company management decided that they need to double the capital budget for a big project? Would you have any role in overseeing, deliberating on that? You kind of see where I'm going. What would your role be in that instance?
That would be more of something done at the board level. That management, certainly for a change like that with regard to the capital budget program, that would be something that would be an annual budget type thing that would be presented to the board. I would obviously, regularly interact with Ryan, and I would fully expect that if he were thinking about something like that in his plan, he would, discuss it with me. And then what we would do is we would ask for, typically what we do is review current and future plans of the company. And so we typically have quarterly portfolio company reviews. And so in the course of discussing that, we would, understand what the plan was, get feedback, and then ultimately, we could, advise or have questions from the management team, but ultimately the management team would present to the board of directors of NMGC for approval in accordance with their typical delegation of authority of the company.
Would it be fair to say that those decisions of the New Mexico board would be autonomous, or is that going too far?
I would say, certainly with regard to the plan, but if the plan were going to, yes, the board has autonomy to make those plans. If the board said as a result of this plan, we therefore need additional investment, then we would, discuss with them the methodology of the additional investment.
Okay. There had been a discovery response, and I'm just gonna ask you at a high level, where Ryan Shell sponsored, and he basically revealed the names of a number of people that had come down from Amira to work in gas company. Would anything of the sort, would any of that kind of cross-pollination occur between any of the entities above gas company in this transaction? Would you be sending any expertise downstream?
Not from above gas company. If you're talking about from a standpoint of being seconded sort of within the organization or becoming an employee of NMGC, then no, that's not currently the plan. We have had, for example, if an employee, if there were a job opening or something like that, an employee wanted to apply to take an opening at another company or something, we wouldn't prohibit that, especially if it were good moves for the company. But there's, we typically don't. And the reason I said from above, all of those companies above are really, they don't have employees and operating folks and things like that. So the operating employees would all sit within like a portfolio company.
Okay.
However, I will say that they would have access to be able to share best practices with the other, like we fully would expect that, for example, the folks at Delta and the folks at NMGC and the folks at Magnolia would talk to each other and share practices. And if one of them has a problem, the others can help them work it out intellectually and things like that. So we fully like, without, this is not a situation where I'm talking about providing necessarily affiliate service, but just sharing best practices with the intellectual manpower you have within the companies.
But this is what you're talking about, if I can characterize it, is sort of peer-to-peer. Delta Utilities, Magnolia Utilities, talking with somebody at gas company, say, hey, we had this issue. How did you handle it? That kind of thing, right?
Yeah. Absolutely. One exception to that, which was pretty extraordinary, was the CEO of Delta Utilities, the service company, was formerly employed as the CFO of Bernhard Capital Partners Management.
Okay.
But prior to his joining Bernhard Capital Partners Management, he had many years of as an audit partner at a major accounting firm, running the accounts of Entergy and Centerpoint. So he was the perfect person to run those companies. So, but he is no longer has a connection to Bernhard Capital Partners. He took a new job to go start the new Delta company.
Okay. And I'm referring to more of a situation that would apply in a holding company kind of a structure, where the holding company would essentially send people to, the parent would send people to like gas company or other affiliates to basically say, here's how we do things in this company. Here's our best practices. So you are now the HR person and teach this company how we operate. You wouldn't do anything like that.
That's correct. You know, it's you know, in the sense, for example, of what I've been able to appreciate over the last year is that there are a number of policies, et cetera, that are Amera policies that the company has been following because it's what you say, you know, it's sort of to fit within the policy structure of Amera or TICO. However, we expect New Mexico Gas will develop its own. We have certain high level, you know, expectations, like we have an ESG policy and things like that that encourage our companies to act in a certain way, but we don't impose a very specific, like there, you know, there's not a BCP HR policy that we expect all of our portfolio companies to follow. We expect the management of the, you know, this company and the board to set those policies. However, you know, if they said we're setting our safety policy and they wanted to call the guys at Delta and said, hey, can we take a look at your safety policy to see what we like from it? That certainly would be a commonplace event.
Kind of slightly shifting, but in the same kind of general realm. The only affiliate transactions that are presented in this application are the IT shared services, right?
That's correct.
Can you think of anything else within that structure that we looked at on page 27 where there would be exchange of services that might qualify as what we call a class 1 transaction?
No, I cannot.
Okay. Madam Hearing Examiner, I wonder if we could take a little break and I could go through my notes.
Okay, we'll take a break, our afternoon recess. We'll come back at 2:30 and resume.
Thank you, ma'am.
Thank you.
Don't forget you're on the YouTube.
The final order in the 15 case, I had it as a separate document, but I can't find it now. It was in a red rope. Maybe it's in that box there. Madam Hearing Examiner, we back in the record?
I'm looking, there he is. How are we doing, Mr. Lee?
Good, Judge. I'm ready when you are.
Okay, great. Let's go back on the record. We're back from our afternoon recess. And Mr. Gould,
Madam Hearing
are you about
Examiner?
finished?
I think the answer has to be yes, just from the way the question was posed. And the answer is yes, but we need to do a couple of housekeeping things if we could. I would like to
Sure.
I'd move the admission of Anna Maria Hearing Exhibit 18, the transcript of the September 12th deposition of Jeffrey Baudier. And just to make the record cleaner, all we're asking for are pages 64 through 65 and 95 through 96, which were the subject of the cross-examination.
64
If
through 65 and 90.
5 through 96. If any party feels that the entire deposition should come in, we wouldn't object, but it does not seem necessary.
And we do object, Your Honor. I mean, the witness has already testified about, these specific questions. There's no need to add the pages. Plus, they're a little non-specific at 64 and 65 and 95 and 96. There's no reference to narrow it down to page numbers. But there's no basis to admit the prior deposition testimony under the circumstances where we've already covered it.
Mr. Gould, what was your exhibit number?
It was hearing exhibit on 18.
Okay, I
And
went too far.
yeah, the reason that we wanted it does provide the context for the questions, and I think it makes the questions understandable, and then it makes Mr. Baudier's clarification understandable as well.
Judge, may I say something off the record?
Yes, sir.
If I don't have a way to break those page numbers out if they're all in one deposition. Thank you, Judge.
We can agree, Madam
you.
Hearing Examiner, to scan them and send them to the parties. We can pull them out today and scan them.
Well, here's anything further from you, Mr. Alvidrez?
No, Your Honor, I made my record on this.
Normally the deposition testimony is used to impeach the witness. Isn't it, Mr. Gould?
Yes, and in fact we did, because he did change his testimony from the deposition.
Well,
And
then
he
you've
was,
already accomplished your goal, right?
oh yeah, I think that I won't say any more, but I think it creates the context for the question and makes it more understandable. If you don't think it does, Madam Hearing Examiner, we'll live with that.
Okay. Yeah, I'm going to sustain the objection. As I indicated, I believe the purpose of the deposition was to try to impeach the witness, and the record will speak for itself. Go ahead, sir.
Two other related things we would ask for, since there seemed to be a lot of controversy around this issue. We would ask for judicial administrative notice of the certification of stipulation in case number 13-00231, dated June 30th, 2014, and the final order in that same case dated August 14th, 2014.
Um, Let me try one more time.
Now, just for your information, we did not attach the final orders to the two exhibits that we uploaded. So if we need to,
I understand that.
okay, thank you.
Let me, yeah, let me just do one thing. And I couldn't get it to work last time. Let's see if I can get it to work this time. I don't have an issue taking administrative notice of well, let me first say, well, no, I want the complete thing. Mr. Gould, I don't have a problem taking administrative notice of a commission final order. I think the procedural rules are pretty clear that I can do that. I just want to make sure that it is a comprehensive incorporation of the final order. So by me saying that, you've already identified the final order and you've identified the certification of stipulation that it adopts. What you haven't included are the two errata notices that hearing examiner Glick included. The first one being July 1st of 2014 that changed two items. It changed page 36 of the certification, wherein the original said within 6 months of closing, and that was changed to within 12 months of closing. And the citation should have been to paragraph 16 of the stipulation, not to Mr. Wall's December supplemental testimony. Second, the errata refers to page 30 of the certification, and it just had to do with how the number 54 cents was noted in the certification. The second errata to that certification that hearing examiner Glick issued on July 7th of 2014 corrected the second sentence on page 33 of the certification, where the word bills should be changed to payments. On the third and fourth lines from the bottom of page 34 of the certification, the parenthetical should be removed. On page 35 of the certification, the first paragraph under section 6N, as in Nancy, should be changed to read, in consultation with staff and interested parties, NMCG will take a fresh look to determine the appropriate response to the February 2011 supply interruption. Stipulation, paragraph 16. Number 4, page 36 of the certification of stipulation. The last paragraph should be changed to read as follows. As part of taking a fresh look to determine the appropriate response to the February 2011 supply interruption, comma, TICO and NMCG will explore third-party participation in a storage facility in paren through ownership or contracted capacity off-take in parenthetical to share the costs and lessen the costs to NMCG ratepayers, period. Within 12 months of closing, NMCG will file a rate case for approval of a proposed solution, period. TICO and NMCG will not seek recovery of the cost of any investment through a rate rider. Period. Stipulation, paragraph 16, with a footnote. This correction supersedes the correction stated in the decretal paragraph A of the first errata notice. So, with those two errata and the second errata correcting the first errata, I would find the stipulation as corrected and adopted by the final order something that would be appropriate to take administrative notice of. Is there any objection to taking administrative notice of the order, including the certification of stipulation as corrected? Hearing none.
On behalf of the main applicant, we do not have an objection, Your Honor, but perhaps could we have, we're not sure what's being admitted. There's an exhibit or, I mean, typically when you've got, I believe the rules require, if we're going to take administrative notice, we're supposed to have the documents presented. And is there going to be, I guess, the collection of the documents to which you are taking administrative notice?
And again, they're not being admitted. I'm taking administrative notice of them, and I can move them over to the Dropbox.
That would be most helpful. Thank you.
Okay.
And Madam Hearing Examiner, one last item, which is we'd ask also to have you take administrative notice of the certification of stipulation in case 15-00327 UT issued on 6 June, that's June 8th, 2016, and the final order in that same case adopting certification of stipulation issued on June 22nd, 2016. And forgive me, my antenna were not as attuned as yours, so I do not know if there were any errata issued with respect to that final order. I do know that in subsequent years, there were some unspent portions of the economic development that were rerouted to another purpose, but I don't think that changes the decretal paragraphs of this order, of those final orders.
There were some subsequent orders or variances, modifications issued in this case. I did not find any errata to hearing examiner Sondheim's certification of stipulation. The final order adopts it, and with the understanding that I will move the final order over. Any objection to me taking administrative notice of the final order in case number 15-00327? This is in the matter of the application of gas company Tico Energy Emera for approval of a merger with Emera US Incorporated.
None by joint applicants. Thank you.
Very well. Hearing no objection, I will take administrative notice of the final order, including the certification of stipulation as described. Mr. Gould.
One last point, I would like to say thank you to Mr. Baudier for his patience. I know that being in the hot seat is perhaps the most difficult position to be in these cases, and thank you for your patience.
Thank you, Mr. Gould. They've all been a pleasure to talk to you, so I appreciate your courtesy.
Okay, well, thank you, and have a good rest of the afternoon, and thank you, Madam Hearing Examiner, for your patience, and we can tender the witness to the next cross-examiner.
Very well. Appreciate it very much.
One thing, I don't know when we're going to do redirect. I guess after everybody finishes, right? So,
right.
Yeah. Okay. Thank you.
Right. Thank you. And you came in right around 3 hours. So appreciate that. Our next cross-examiner, according to the agreement, Ms. Nanasi is NEE. And you have reserved 2 hours, I think, for Mr. Baudier. So please go ahead.
Thank you, Madam Hearing Examiner. I am sure I'll need to borrow some time from some other people, but we'll deal with that when we get to that point, okay?
Sure, go ahead.
Okay, and do you have an idea about a time that you want to stop for the afternoon break? Just so I can...
Well, let's go as close to, and we'll see where you are at 5.
Oh, you're not going to take an afternoon break of 10 minutes or something?
I just did.
Okay. Here we go.
All right.
Good afternoon, Mr. Baudier. You are the president of Saturn Utilities Holdco and senior managing director of Bernhard Capital Partners Management LP, correct?
Good afternoon, Ms. Anasi. Yes, that is correct.
You would agree that the commission must determine if Bernhard Capital Partners, also known as BCP, is fit to be the owner of New Mexico Gas Company, regardless of Emera's desire to sell New Mexico Gas Company, right?
I may take exception to the classifications of the parties, but obviously there's a requirement that the financial wherewithal and capabilities of the new owner be assessed as part of the test.
It's not only the financial qualifications, though, correct?
Right. It's a 6-part criteria.
And that's independent of whether Emera wants to sell New Mexico Gas Company or not.
I guess I'm confused by that because I don't think we'd be applying the test if there weren't a desire for Emera to sell. So we wouldn't be asking these questions.
Okay, but what I'm asking you is, the commission must determine if BCP and Saturn Utilities Holdco is a fit to be the new owner of New Mexico Gas Company, regardless of Emera's desires.
I'm still a little bit confused by the question, but I guess the best way I can answer it is I don't think Emera's desires factor necessarily into the equation, except for the fact, as I discussed earlier in my testimony and with Mr. Gould, that they do want to sell and exit the investment in New Mexico.
Could I just get one clarification at this point? Ms. Nanasi keeps saying Saturn Holdco and BCP are the owners. BCP, I didn't think I heard you earlier. BCP is not an owner, is it?
That depending on the entity, you are correct, Your Honor, which is why I had a little bit difficulty answering the question. But Saturn Utilities Holding Company will be the direct owner of Tico Energy LLC, which is the entity, and then but indirectly up the chain, the BCP infrastructure funds will indirectly own, but not BCP management, which is the other entity we've been talking.
Okay. And is there a plain old just BCP that's over BCP management?
No, that is, and that's been a little bit of the sloppiness that I take the blame for. And I try to explain in the beginning of my testimony. I believe I talk about it on page 8, but
could you just say page 8 of which testimony?
I'm sorry, page 8 of my revised direct testimony. But and you're absolutely correct, Your Honor, is that BCP is not a corporate entity, and we get into this habit of just calling all the entities collectively as sort of BCP, but that is not legally correct.
And I stopped your time, Ms. Nasi. So I'm not on your dime. But just so we're clear here from the beginning. When you say at line 23, continuing on to the testimony that you've just referred to, BCP through its supported funds has deployed capital in 5 funds across several strategies. Now, are these the 5 funds that you have testified earlier in response to Mr. Gould's questions? The 3 infrastructure funds that will be the owners, and then the 2 other infrastructure funds that potentially will contribute to the equity.
Slightly different, Your Honor, but there are 5 funds. There's actually 3 funds, and I hate to overly confuse it. There's actually 3 funds in what we call the private equity services funds, and there are 2 funds in the infrastructure fund. But when that reference is being made here, we're not breaking out what we call the fund in the fund A. You know, you see infrastructure 2 has a fund and a fund A. We we're referring to Infra Fund 2 as one fund, Infra Fund 1 as one fund, and then there are 3 services funds. And so those are in the GDP, and we lay out like which of those funds own all of those portfolio companies that are set forth next to them in the GDP. And that's what's being referenced.
Okay. Referenced. Is there a 6th fund?
No, there's not, but the thing that I think is causing you some confusion is that there are entities, there's sort of bifurcated entities within each fund, which is why there's a -A. And that is strictly because different LPs may sit in A, or they sit in the other part of the fund. And so although they're separate, they're listed as separate entities, we consider them all part of the same fund. But every fund has that type of bifurcation.
And just so I understand, or attempt to understand, you further explain on page 28 of your testimony. For example, please describe the question posed at line 5. Please describe the role of the BCP infrastructure funds in the transaction. And then at line 16, you're saying BCP infrastructure funds own 100% of the limited partnership interest in Saturn Aggregator, who's managed by its general partner, Saturn Aggregator GP. Saturn Aggregator owns 100% of the limited partnership interest in Saturn Topco, comma, which is managed by its general partner, Saturn Topco GP. Both Saturn Aggregator GP and Saturn Topco GP are owned 100% by the BCP infrastructure funds. Saturn Topco owns 100% of the membership interest in Saturn Utilities, LLC. And the intermediate companies are included as joint applicants. So, Mr. Baudier, you with with all of these limited partnerships and LLCs and aggregators, you can understand why we might be a bit confused, can't you?
I can understand how it takes a bit to get used to, but I would posit to you, Your Honor, that it's really not different than the current structure with Amera, except that Amera uses corporations as opposed to partnerships. And so the use of partnerships requires a little bit of an extra branch, so to speak, here. However, the structure and the ring fencing is not only effectively the same, it is exactly the same structure that is utilized in El Paso, as well as what was utilized in the Lindsay Goldberg structure, and is used by thousands of private equity infrastructure funds across the world. And so this is an extremely common structure that you see above the Saturn entities for purposes of the limited partnerships involved in the infrastructure investments.
And what is the purpose of having, is it to limit liability?
Well, that's part of it, but because the investors have different, they come from different, they're not coming under a holding company, they're investors. And so they don't create a company and have shares of stock in that company. They create a partnership. and they participate by being partners together in an investment. And we create some distinctions because some of those investors are public pension funds that are tax exempt, and some are even super tax exempt, and some are U.S. taxpayers. And so by using the LP structure, that allows each investor to deal with their own tax liability, so that there's not a corporate entity that's trying to figure out what some individual investor's tax responsibility is. So the LP structures allow that to just flow through, and they deal with that themselves.
Is there any other benefit to having that limited partner structure as opposed to a company structure?
Well, it obviously creates the ring fencing, and what it allows us to do is, so if you look at Saturn Utilities LLC and Saturn Utilities Holdco, that is where debt would sit. If there's, and that we talk about that Holdco debt, that is what allows the debt to be put at that entity and ring fenced and non-recourse to New Mexico Gas Company, because there is no debt at the fund level, at the LP level. And so it allows us to provide an entity here that can be the advantage of creating additional debt, but it's ring fenced, and we actually have superior ring fencing to what exists before, because the debt that was held above New Mexico Gas Company before was held at New Mexico Gas Intermediate, which doesn't have as much separation as Saturn Utilities Holdco does from New Mexico Gas. So it just creates additional protection of the operating company from what happens upstream.
Thank you, Mr. Baudier. Thank you, Ms. Nanasi, for allowing me to come into your time. It's important for my understanding, especially as the daughter of a carpenter. I can't get to the roof until I know what my foundation is of my house. So you can go ahead, Ms. Nanasi.
I can tell you, Judge, as the son of a mechanic, it took me a lot of years to figure this out.
Thank you. So if you could go back to page 8 of your revised application direct, and there you say at the end of line 19, I use BCP to refer collectively to BCP management and the investment funds BCP management supports, including the BCP applicants, right? You say that?
I do say that.
Okay. And so can we have that same understanding going forward, except if you want to make that distinction in a specific answer?
Yes, if there's a requirement that a specific entity be referred to, I can make that clarification. I will attempt to.
Okay, but otherwise it will be according to your statement that I just read of yours. Is that fair?
I'm fine with that.
You understand that Emera wanted to sell one of two or two of its investments, correct?
I'm not sure what entirely their total plans were, but there's been some reference in this case to a Labrador pipeline that they sold during the same time that this transaction was pending.
Thank you for answering my next question. All interveners are opposed to the transaction, primarily basing their conclusion that the risk of BCP's lack of experience is not outweighed by the benefits offered by BCP. Is that your understanding?
I'm not sure I can answer that. I mean, I think the interveners can describe what their position is.
Okay, let's turn to page 7 of your revised rebuttal. And I believe line 8, you say here, certain of the parties make the conclusory allegation that the benefits under the transaction are inadequate, but provide little or no elaboration to support their claims. Is that right?
That's what I say, correct.
Okay. When do you estimate that a final order in this case will be issued? Based on your discussion with Mr. Gould, is it somewhere between February and April? Is that your guess?
I really have no idea. I would certainly be hopeful for that, but I have no idea.
Okay. So, and if you go back to Mr. Tuminello's JA Exhibit PIT-2, page 16 of 17, the high-level transition timeline that you were also discussing with Mr. Gould, if you could just go back to that for a minute.
Oh, okay, 1 second, please. I'm locating it. Yes, ma'am, I have it.
Thank you. So you pointed out with Mr. Gould that underneath the first bar that runs across the timeline, that there is this statement that says joint application filed July 3rd, 2025, right? You see that?
That's correct.
Okay, and so the
Yes.
first, like we'll call it brighter orange numbers are quote -7654321, right?
That's correct.
Okay, so if -7 is July 3rd, 2025, and you add 6 months to that, right? So July, August, September, October, November, December, January.
I think these are 7 months.
Okay, 7 months. So, and then you go to February, then that would be February 2026 would be +1. Is that right?
Based upon that counting, correct.
Okay. So let me ask you this. And so that's what his timeline showed for an approximate, and it says there, transaction close, right? You see that regulatory proceedings, transaction close, right?
Correct.
Okay. And what you said was you were hopeful that it would be somewhere between, in the first quarter, somewhere between February and April of 2026, correct?
Hopeful, correct. I don't know if that's reasonable to have that
more
hope.
realistic. But let's operate on that. Okay. Let me ask you this. Joint applicants agreed to the $22.4 million rate credit amount because that was what was proposed by Mr. Etheridge, witness for U.S. Department of Energy representing the federal executive agencies. Is that correct?
We did agree to that following seeing their testimony, correct?
Okay. Mr. Etheridge testified that the $22.4 million rate credit amount be calculated on a volumetric basis, which would have meant a much larger rate credit for his clients and a much smaller rate credit for residential ratepayers. Is that also correct?
That is basically correct, yes.
The 22.4 million, if made on a per capita distribution as joint applicants prefer, would amount to $40.78 for an average residential ratepayer, which equals $3.39 per month, correct?
Could I ask what you're referring to so that I could follow along?
Well, I mean, I can refer you to in this moment, but hopefully we won't have to do this all the time, but your revised exhibit 3 rebuttal at page 9, line 10. 10 and 11.
So yes, it says the 22,400,000 rate credit divided by 549,284 customers equals.
I'm sorry, sir. I'm sorry, sir. You're reading just a little too fast. 22
Slow down.
400,000 rate credit.
I'm sorry, I apologize. 22,400,000 rate credit divided by 549,284 total customers equals $40.78.
And then if you divide that by 12, that equals $3.39 per month. Is that correct?
I haven't done the math, but I wouldn't argue with you. That sounds correct.
Okay. You know that when Mr. Sandberg proposed a specific rate credit amount in his original direct testimony, he suggested that the rate credit be between $40 and $90 million. Is that your recollection?
I'd have to go back and look at that testimony, but I don't have a reason to disagree with you.
Thank you. Can you please turn to page 11 of your revised rebuttal? And read the question on line 21 and 22 and the first sentence on page 12 answering that question.
I'm going to object, Your Honor, to just reading the first line, because that's not the full answer. It's only a single line. And I've had issues where this has come up before, where I've had witnesses who were asked to read part of an answer. And then in the briefing, and up on appeal sometimes, it's represented that the witness Smith testified to XYZ, when all witness Smith did was read an excerpt from something. So I do object to this manner of just having a partial response read into the record.
Madam Hearing Examiner, that's what redirect is for. And if he wants to go into it, this is the only part that I need, that I'm focused on right now. So it's about the rate freeze and what it entails. So that's all I want to know about. And I don't think there's anything misleading about this question that I've just asked.
Well, I think it's really only fair that he look at the whole answer.
Okay, I withdraw my question and I'll ask it a different way.
Okay.
Sir, at this part of your testimony, you ask yourself, what are the parties' positions with respect to the proposed rate freeze? Is that right?
That is correct.
And what joint applicants have committed to is that New Mexico Gas Company will not file its next general rate case before September 30th, 2026. Is that also correct?
That is correct.
Now, if we are at a February to April final order in this case, and let's pick March because it's in between, and you add somewhere between 3 to 6 months for NMGC to file a rate case, we would be between, if it's March and it's 3 months, it's April, May, June. And if it's 6 months, it's July, August, September of 2026 that would, if the final order was issued in March of 2026, joint applicant, NMDC, excuse me, would file their rate case somewhere between June and September 2026. Is that correct?
There's a lot of assumptions in your question. It depends on how long it took them to prepare the rate case. But if you're assuming that that's couldn't be begun until after the final order went into effect, then your timing, based upon your set of assumptions, would be correct.
So the fact that NMGC, strike that. The fact that BCP and NMGC have agreed to a commitment to not file a rate case till September 30th, 2026 is somewhere between 0 and a couple of $1 million benefit. If our assumptions, both of our assumptions, are correct.
That is incorrect.
Why?
Well, first, I don't understand how you arrive at your calculation of 0 to a couple $1 million.
Okay, let's go through that. How much was the last rate increase from NMGC?
I don't know exactly, but my understanding is that it was somewhere in the neighborhood of 40 to 50 million.
Okay, so now I would like you to pull up what I have included as a demonstrative exhibit, the certification of stipulation in case 23-00255 UT, and go to
What exhibit number?
Give me 1 second and I'll tell you. I don't think that I labeled it as an exhibit. I labeled it as a demonstrative exhibit. And if you tell me if people who are helping you
We're
are
trying to find it now.
It's 23-255 UT, which is the certification of stipulation that was entered on June 6, 2024 with the same hearing examiner. And
What
once,
page?
if you could go to page 61, which is PDF page 68.
Excuse me, was this one of your late exhibits?
Nope.
And you represent Ms. Nanasi that that the certification was adopted by the commission?
Yes, it was. Now, I did just, when all the conversation was happening with you and Mr. Gould, I did upload recently the final order that adopted this in total.
Okay. I don't remember using yellow highlight when I wrote the RD.
Didn't, but
Oh.
I did, so we could expedite this because you know that I don't have as much time as I want. I want to be able to focus the witness's attention to bullet 2.
Can you tell me what page you're on?
Yes,
Yeah, just once.
It's page.
Let me get it.
But it's PDF page 68.
I'm sorry, again, Mr. Nassi, it's page
61, which is labeled on the bottom, but it's PDF page 68 of 188.
Thank you.
Tell me when you're there, Mr. Baudier.
I am there.
Okay, so do you see in the portion that I highlighted, but was not in the original, that a negotiated increase in revenues to be recovered through NMGC's base rates of $30 million? Do you see that?
I see that language in the document.
Okay, so
I still don't understand what this document is. Is this a rate case stipulation?
yes, it is. It's the certification of stipulation in the rate case.
Okay, I've never seen this document before.
Okay, well, it was uploaded a couple of days ago, when we had to put our documents in to Dropbox. And so now what I'm telling you is that the last rate case, there was a $30 million rate increase for New Mexico Gas Company ratepayers.
And Your Honor, I object. This Ms. Nanasi is testifying.
Yeah.
Mr. has testified he hasn't seen this before. He's given what his understanding was of the last rate case request.
And he was correct. And so now I'm pointing out through this document that it wasn't a $40 or $50 million rate increase. It was a $30 million rate increase. And there's no reason that this document is not to be taken for what it actually is.
Well, this document doesn't say what the original request was, or at least it doesn't in the highlighted portions anyway. So, but anyway, in any event, he hasn't seen this. I don't think it's appropriate to ask him questions about it.
Well, I do think
Mr. Baudier, this is being represented as a stipulation of the commission that was adopted by a final order. You've indicated that you are not familiar with this document. Do you have any reason to doubt the document says what it says?
I don't doubt, Your Honor, that it says what it says, and I don't doubt the validity of the document. However, the statement that a negotiated increase of $30 million and giving a specific ROE and capital structure without seeing the entirety of the rate case and understanding all of the parameters that went into the negotiated settlement, I don't have any basis to determine why 30 million was the number that was ultimately negotiated to.
Okay.
Or that
With that-
represented the required revenue requested by NMGC.
Very well, sir. Why don't you go ahead and move on? I think he is testified as to his understanding of what the document is, Ms. Denasi.
Thank you. Sir, do you have any idea how much the actual rate case increase before this last rate increase was?
Again, I do not know.
Okay, well, if I told you that it was under $20 million in case 21-00267 UT, which has also been uploaded, would you accept that subject to check?
Objection, Your Honor. Again, she's testifying.
Yeah. Ms. Nanasi, are you familiar, sir, you said you're not familiar with the prior rate case? 21-267?
That is correct.
Okay. Why don't you move on?
So if you could please go to Can you just tell us, can you explain to us what's the benefit to customers of a rate freeze?
If the rate case were filed in the normal cadence, which would have been September just a month ago or 2 months ago, then the rates would have taken based upon my conversations with Mr. Shell and the organization, the anticipation was that that rate case revenue requirement would be in the neighborhood of $30 to $40 million. The delay of filing that rate case creates that same amount of benefit on behalf of the ratepayers, because it is foregoing the recovery of that revenue requirement for an additional 1 year period and for an entire cadence of a rate case.
Sir, what is the benefit to ratepayers of a rate freeze?
In this case, it's $30 to $40 million.
But New Mexico Gas Committee chose not to file that rate case, right?
No, the rate case is being delayed because of this transaction. And the reason that the rate case is being delayed does not take it away from being a benefit. The cause of the delay has no bearing on whether it's a benefit or not. It is absolutely a benefit objectively.
But the only benefit that you're offering right now in this rate case, in this application, is that you won't file a rate case until September 30th, 2026. Is that correct?
That's not the only benefit that's being provided in this rate case. That's one of the benefits. And that benefit is worth $30 to $40 million.
So, but in your application, you offered no rate freeze. Is that right?
In the initial application?
Yeah.
I believe so. That's correct.
Okay. And so this revised testimony, there you say that you're offering a rate freeze and that the benefit has to do with that you won't file, or NMGC won't file, a new rate case until September 30th, 2026, correct?
That's correct.
Now, you know that a rate freeze has been a standard benefit in case 08-0078 UT, 13-00231 UT, 15-00327 UT, and 19-00234 UT. Correct?
I don't have any reason to disagree with you on that.
And you know that in the Avangrid case, when it sought to, you know about the Avangrid case, right?
Very little. I
Okay.
only know that it existed. I don't know any of the terms of it.
Well, in the Avangrid case, when it sought to own, merge with P&M in case 20-00222 UT, the parties to the stipulation agreed to a rate freeze, correct?
I do not know.
So if you could turn to JMB2, which is on page 48 of your revised rebuttal.
Oh, rebuttal.
Can I have 10 seconds, Your Honor?
Go ahead.
Are you there?
We are.
Yes, ma'am. I believe you're referring to the table that's embedded in the testimony.
Yes.
Yes, there.
It's fair to say that the quote rate case delay that you have there on the second line, the $30 to $40 million is about half the amount of the total monetary benefit.
Towards the end of the no, I would say it's closer to a third, but the high end at 40 and the low end, it depends on how you're looking at, but it's a significant portion for sure.
And you know that Mr. Walters, New Mexico area's witness, said that he too believed that this rate case delay was worth about $4 million, not the $30 to $40 million that you say here. Is that right?
I'm going to object. That mischaracterizes the corrected testimony by Mr. Walters.
I believe that if we go back to your testimony, Mr. Baudier, and we go back to page where was it? If we go back to page 12, line 7, does it not say in your testimony that NM area asserts that the deferral of New Mexico gas next rate case to September 30th, 2026 results in a net present value savings of $4.5 million?
Again,
I'm sorry, let me find the page.
Well, Mr. Nassi has
Object.
the language.
Hold on, I
testimony.
can't hear both people at the same time.
Mr. Alvidrez is not making an objection, he's testifying.
No, she represented what Mr. Walters testified to. He has since filed revised testimony that no longer backs up the $4.5 million calculation to which she is referred.
So you're saying, just wait. You're saying that the footnote 13 in Mr. Baudier's testimony on page 12, which says Walter's direct revised application at 33 is incorrect. Is that right, Mr. Alvidrez?
No, Your Honor, that is correct. But what has occurred since then is that Mr. Walters filed corrected testimony. It was what was uploaded as corrected testimony that no longer has that $4.5 million in it. So Mr. Walters has changed his testimony.
Okay, so, but your witness didn't change his.
We didn't have an opportunity to.
Okay, when are you saying that the corrected testimony got filed?
It was uploaded whenever the upload was. We may have gotten notice of it
last
a day
week?
in advance. Yes.
Okay. You aware of that, Ms. Nanasi?
I was aware that Mr. Walters made corrections. I did not know it was to this number. Clearly, Mr. Baudier had the opportunity. He made corrections when he was introduced by Mr. Alvidrez. And I think that what is appropriate here is that an objection is made with an actual foundational or something else, which has not been made. I am going on Mr. Baudier's testimony. It's right in front of us. If Mr. Alvidrez wants to supposedly clean it up and redirect, he has that opportunity. But I don't know that Mr. Walters changed that number.
Okay.
Your Honor, the original question was, didn't Mr. Walters, come up with this number? But he changed his number.
Well,
and
I think she's right. You can't testify, Mr. Alvidrez. The testimony stands as it is, and that was your testimony, right, Mr. Baudier? Page 12.
Based at the time I filed it, yes, that was based upon what we had.
Okay. Go ahead, Ms. Nanasi.
In its acquisition of Delta Utilities, the BCP applicants committed to an actual rate freeze not to file a rate proceeding within 33 months post-closing of the transaction, correct?
That's incorrect. The BCP applicants did not, were not engaged in the Delta acquisition. Those were, yeah, there were certain BCP related entities that were involved, but it wasn't the BCP applicants in this case.
And so the Delta Utilities, when you had that transaction, you agreed to a 33-month post-closing rate freeze from the transaction. Is that right?
There was a very specific agreement, and that was with the New Orleans City Council. That was much more consistent with the rate cadence of New Orleans, and there is an annual rate adjustment mechanism. So those utilities are able to go for much longer periods without filing a rate case, and they get adjusted annually through rate stabilization plans and formula rate adjustments. So, for example, as I mentioned in my rebuttal testimony, CenterPoint went 15 years without a rate case. And so it's very frequent to have long periods without rate cases in those jurisdictions because there's other annual adjustment mechanisms. And that was actually the only concession related to that matter.
So the answer is yes.
In the context of that case, yes.
Nowhere in the joint applicant's testimony did it produce a side-by-side analysis that compares the costs and benefits for customers of the Emera transaction in case 15327 UT compared to the cost and benefits for customers of this transaction, did they?
That's correct.
Nowhere in the joint applicant's testimony did it produce a side-by-side analysis that compares the costs and benefits for customers of the JP Morgan El Paso Electric transaction in case 19234 compared to the cost and benefits for customers of this transaction, did you?
That is correct, except I would say that we make reference to the El Paso Electric ring fencing proposals that we followed substantially.
Is BCP proposing a majority independent board in this case?
Yes, we are. That's set forth in my testimony as well as in the GDP, which is attached as Bodier 3, I believe.
You are proposing a majority independent board?
Yes, that's correct. That's in my testimony.
And where is it in your testimony? Because
let him look.
Mm-hmm.
I'm looking in the revised GDP.
You're testifying on page 35 regarding the board at close, aren't you?
I'm sure I am, Your Honor. I think there are multiple places in which I testify about the board, but I know it's summarized in the GDP as well. 35?
Yes, sir.
Yes.
That's 35 of the direct.
35 of the direct testimony. So the current, starting on line, well, let's say starting on line 7, ask the question, how will the board be determined after the closing? And starting on line 9, I answer that the local NMGC board will continue substantially similar form.
I'm sorry, sir. Starting on line 9, I answer
after closing the transaction, the local New Mexico or NMGC board, will continue in substantially similar form and will continue to provide local governance, oversight, and guidance of the strategy and business plans of the NMGC management team.
Sir, how many board members are there currently?
There are 9 board members. Could I continue?
Well, let me just ask you this. I don't want you to read all your testimony. So if there's 9 board members and on line 16, you said 3 of them will be disinterested directors, how is that a majority? That's what I wanted to ask you.
So on page 4, on line, let's see. Let's start on 12. The current board consists of the president of NMGC, 2 Emera employees, and then local and community leaders selected to promote diversity on the NMGC board, consistent with good governance practice, with the majority composed of local business and community leaders. As part of the regulatory commitments, at least 3 of the NMGC directors will be disinterested. They already have 6 independent board members who are the local board members, and we are actually increasing the commitment to make at least 3 of those 6 disinterested, which is a higher standard than independent.
But sir, I asked you about a majority disinterested directors, right?
No, you asked if there were majority independent.
Well, let me ask you this. Are there a majority of disinterested directors that will be on the NMGC board going forward?
There could be, but there's a guarantee that at least 3 of them will be. Currently, there are 6 independents, as I mentioned. So there could eventually be 6 disinterested, but there will be at least 3.
And there is a New York Stock Exchange definition of a disinterested director. Do you understand that?
Yes, I do understand.
And do you know?
And I cited.
And what? I'm sorry.
And I include that definition in our GDP for disinterested directors, which is why I was looking for that exhibit before, which is JMB3, I believe.
In one of the benefits listed in the private equity buyout of the El Paso Electric in case 19-00234 UT was that it was going to have a majority disinterested board of directors. Do you understand that to be the case?
I'm not familiar with it, but I don't disagree with you.
But that is not what you have agreed to in this case.
That was a different case.
When Delta Utilities chose the Oracle IT system, did it perform a benefit cost analysis that demonstrated its cost effectiveness?
I'm sure they did. That would be a question better answered by Mr. Tuminello and Mr. Miko.
Okay, I will ask them that. But when you say you're sure they did, is that evidence part of this record?
I don't believe so.
Madam
It could be in their testimony, but I'm not aware.
Examiner, I don't know who's in the room with Mr. Baudier, but he has repeatedly looked over to some person or persons there before he answers, and I believe that your procedural order in this case forbid that. Any communication when the witness is on the stand, especially during a pending question. And I'm concerned that there's been a violation of that. And I'm trying to ask you to enforce your order with this witness.
I'd like to respond. There's been absolutely no violation of the order nor any communication to assist Mr. Baudier with respect to any of his answers other than to provide him with copies of exhibits that the examiners have been asking him to look at. That's the sum total. I remain on the camera at all times. You can see I'm not saying anything to him. Mr. Domi's in here. You can see he's not saying anything. There is absolutely nothing untoward that has happened or will happen.
Mr. Baudier, you understand that your answers have to be yours and yours alone, correct?
Absolutely, Your Honor.
Very well. With that, go ahead, Ms. Anasi.
Thank you. Where in the record is there a benefit cost analysis that demonstrates that the new Oracle IT system that BCP is choosing is more cost effective versus an upgrade to New Mexico Gas Company's forthcoming SAP cloud system?
There's some reference to it in my testimony, as well as in the testimonies of Mr. Tuminello and Mr. Miko.
And what is that benefit cost analysis? Where is that?
It is on pages 67 and 68 of my testimony, and it was discussed during my cross by Mr. Gould.
Now, if I may, did you and Mr. Gould discuss that there is a alleged cost benefit between the Oracle system, the Oracle cloud system, and the SAP current system? Is that right? That's what your benefits discuss.
No, I believe you would have to ask Mr. Tuminello and Mr. Miko the comparison, but my understanding is that it assumed what's called the full life of the asset. So it would be continuing on both platforms. There is no avoiding that SAP has to be upgraded, so it can't maintain in its current configuration.
And was there a performance-based analysis that was done between SAP Cloud and Oracle Cloud?
You would have to ask Mr. Miko and Mr. Tuminello.
Okay, so as you know right now, is there any benefit cost analysis between those two IT systems that's in the record?
Yes, I believe it's in the testimonies of Mr. Tuminello and Mr. Miko and any exhibits provided along with those.
Okay, I will ask them. Was there any benefit cost analysis that demonstrates that the new Oracle IT system that BCP is choosing is more cost effective relative to the services provided for any other IT system?
I am not sure. You'd have to ask Mr. Miko and Mr. Tuminello.
Do you agree with Mr. Tuminello that BCP chose the migration to Oracle's IT system with BCP's Delta Utilities as BCP's way to address interveners' concern that there are no synergies in this case?
I would have to see that testimony. I'm not sure what you're referring to.
I'll just ask Mr. Tuminello, but it was a Tuminello revised direct at page 7. Let me move on. New Mexico Gas will add 20 jobs in New Mexico if this transaction is approved, correct?
Yes, that's correct.
Those salaries will have to be paid for by NMGC customers, right?
Those are calculated into the benefits calculation.
So the answer is yes.
Yes.
Those new employees will have to be trained, correct?
They could. It depends upon the individual employee. They may already be experienced.
For some period of time, New Mexico Gas Company customers will be paying for both TICO and or Amera employees, and concurrently for the New Mexico Gas or Delta Utilities employees, right? And it could be
Yes,
up,
those will,
excuse me, I'm sorry.
I'm sorry. Those are included in the cost estimate analysis.
Okay, so essentially for up to 2 years, it's possible that NMGC ratepayers will be double paying for the shared IT services and maybe other services, correct?
No, that's not possible. The what's called the TSA overlap, that is a expected and regular component of these transitions, does not last for the entirety of the TSA. It is timed in a way so that it makes the most efficient use of onboarding the new employees with the system. So it's not anything like the entire period of the TSA. And as I mentioned, it's been factored into the benefits, which show relative cost savings to the existing plan.
I understand that, and I know that you originally had it that there was a lesser amount of TSA time period, but then you extended that to 2 years, right? So it is legally possible.
Question. What's your question, Ms. Nasi?
So it's legally possible that ratepayers will be double paying for that 2-year period. Is that correct?
My answer to the question was that they would not be. It
At
would be some shorter time than that, which has
Okay.
been factored into the analysis.
So do you know how long? I know you said that you want it to be a year, but even for 1 year, they'll be double paying, right?
No, that's not correct. And it's shown in the report of what the cost of the TSA overlap costs are. That's provided in the cost estimate. So that would be the best handled in the testimony of Mr. Tuminello and Mr. Miko, who go through those cost summaries.
I understand that you think that there's still a benefit, but isn't it true that if everything goes well and there's only 1 year of essentially double resourcing from these different entities, ratepayers are going to be paying for those costs?
Again, there's been no indication that there'll be 1 year of double payment. And again, those costs have already been factored in to the benefits.
However long it takes, there's going to be a double payment. Is that right? I understand that it's been factored in, but there will be a double payment. Is that right?
There will be some period where there will be what's called overlap costs, which are expected and part of the transition process.
Thank you. Approximately how much have ratepayers been paying for the TICO Amera shared service costs per year?
The latest numbers I had seen were, I think, 11.8 million. I believe that was for 2024.
Of course, like for any employer, 20 new employees in New Mexico may be a smooth transition or a bumpy one or somewhere in between, given the experience, competency, and individual abilities of the trainers and the employees, correct?
Well, certainly.
At this point, you'd agree that these 20 new employees in New Mexico might be a benefit or a detriment compared to the currently employed personnel doing the same or similar jobs. And because no one has a silver ball that can predict the future, we can't know for sure what will happen.
I disagree. I think the New Mexico Gas, which has a workforce of 750 people, the integration of and training of 20 people is is actually a very common thing for them. They have very good staff. And so while you can't certainly see the future, we have projected those costs, and we projected that those costs would produce a benefit relative to the costs that are being paid under the Amera-TICO TSA.
Can you turn to page 44 of your rebuttal?
Yes, ma'am.
On line 18, you say, there is an entity named Elevation Home Energy Solutions Incorporated, in parentheses, Elevation, quote unquote, which is part of the BCP management's investment portfolio. Any alleged violations by Elevation and Railworks are not reflective of BCP management, which neither owns nor operates either of these companies. BCP management is merely the manager of the funds that own these companies. Moreover, if the transaction closes, Elevation and Railworks will remain wholly unrelated to NMGC. Under these circumstances, their alleged violations have no relevance to the transaction at hand. Did I read that correctly?
Yes, you read it correctly.
And Your Honor, I need to lodge an objection or seek clarification. This portion of the rebuttal testimony relates to the now stricken George testimony. So that I take it is now out of the case. And questions, this portion of the rebuttal testimony really is no longer applicable under your earlier ruling.
Madam Hearing Examiner, once again, Mr. Alvidrez did not lodge an objection. He testified. First of all, he's absolutely wrong. The part in this testimony that was struck by Mr. Baudier has all to do with national water infrastructure and documents that were erroneously included. I am now asking him about elevation. That's what I asked in my question. And
Mr. Baudier, is Elevation an affiliate?
I don't know what you mean by affiliate. Elevation is a portfolio company of one of the BC management portfolios, but I don't know how Mr. George would have any knowledge of that. Or Mr. George has nothing. It had nothing to do with the New Orleans case and Mr. George, in which he was involved.
Ms.
And I don't
Nanasi?
know, and I don't know what these violations are that they're referring to.
This has nothing to do right now. What I just read has nothing to do with Mr. George. It's about elevation.
Okay.
Ms. Nanasi,
Okay, then
the
I'm gonna
question-
hang on just a second, Mr. Baudier. Okay, so this is in his testimony. There's been an objection that this is part of the stricken testimony of Mr. George. Ms. Nanasi is representing, no, it's not. So I'll take this under advisement and I want you to answer the question. Which you have not posed. There was an objection before you ask your question. So go ahead and ask your question, Ms. Nanasi.
Did I read your testimony correctly?
You did read it correctly. Yes, ma'am.
Did you write these sentences or did your lawyers?
We wrote them together.
Here you are making 2 points as I understand your testimony. One, that BCP management doesn't own or operate the funds in BCP's portfolio. And two, that these other companies in BCP's portfolio have nothing to do with NMGC. Is that a correct assessment of what I just read and you wrote with your lawyers?
I don't believe so. Can you repeat your question?
Yes. Based on this testimony, on page 44 to 45, starting where I started, there's an entity named Elevation, etc., till the end. I'm asking you, are you making 2 points here? One, that BCP management doesn't own or operate the funds in BCP's portfolio. And two, that these other companies in BCP's portfolio have nothing to do with NMGC. Are those the points that you're making there?
Not the first one. It says BCP management neither owns nor operates either of these companies. Your question or your statement referenced the funds. It doesn't own the funds either, but the statement is that BCP management neither owns nor operates either of the companies, which is correct. It is a manager of the funds that own the companies. But regardless, and I don't know what violations you're referring to, or whether they refer to any time period in which a BCP fund owned these companies even, but I don't understand what you're trying to suggest that their violations would have anything to do with BCP management. That's what I'm trying to say.
Can you turn to, so here, let me just follow up on that before I go into my next question. So here you are making the distinction between BCP management and BCP funds, right?
Well, while I'm making that distinction, BCP funds would have no responsibility either, because BCP funds does not operate or manage these companies either.
Okay.
So either way, the statement would be the same.
Okay. Can you turn to New Energy Economy Exhibit 10?
Excuse me, I'm sorry. I'm getting everything mixed up. Okay, I believe I have the right exhibit. It looks like joint applicant's response to NEE's second set of interrogatories and requests.
Yes. So if you could just flip through these, and I'm going to just ask you, were you the respondent to New Energy Economy interrogatories 2-31, 2-32, 2-34, and 2-47?
So, yes, the responses that are attributed to my name, I was involved in drafting, and they were prepared under my control and with my input.
And it also includes a self-affirmation here that states, quote, "I know the contents of my respective responses, and they are true and accurate based on my personal knowledge and belief." Is that also correct?
That is correct.
Okay, could you turn to the first one on 2-31? And here, would it be fair to sum up what you say here, consistent with the testimony that we just discussed, that individuals employed and engaged by Bernhard Capital Partners do not and will not operate or manage BCP for portfolio companies?
Well, the answer is stated here as it is. That's a portion of the answer, and then it's an entire, paragraph responding to that. So I would not say that your summarization captures the full answer.
Okay, but would it be fair to sum up what you say is consistent with the testimony that we just discussed, that individuals employed and engaged by BCP do not and will not operate or manage BCP portfolio companies, and that this would be the same if the application with NMGC is approved?
That's certainly what the first sentence says.
Okay, so who would own NMGC then, if BCP wouldn't own it?
I'm not sure I understand your question.
Who owns NMGC if this transaction is approved?
I did not say in this sentence that BCP infrastructure funds or other would not own it. It says they would not operate or manage NMGC.
Okay. Now I'm just asking you another question. Who owns NMGC if this acquisition was approved?
Saturn Utilities Holdco LLC.
Wait a minute, I'm not hearing you for some reason. I see your lips moving.
Let me try again. Saturn Utilities Holdco LLC.
And upstream from that, the BCP infrastructure funds would own it as well, correct?
Upstream of that, indirectly, yes.
Who are the investors in Saturn Holdco?
Saturn Utility Holdco is 100% owned by Saturn Utilities LLC, its parent.
And who are those investors?
Ultimately, up the chain, they would be the investors in the BCP infrastructure funds listed at the top of the chain.
And who would those investors be in the BCP infrastructure funds?
That is confidential information. It's been provided confidentially.
So is it joint applicant's position in this case that you want the commission to approve the sale of NMGC, a regulated company, to entities that the public will not know?
Certainly, everyone who has intervened in this case has seen who those entities are, and the PRC as well as the hearing officers have access to that information.
And you understand that NMGC is a public utility, correct?
It's privately owned.
But do you understand that it's actually a public utility under the laws of the state of New Mexico?
Yes, but I don't understand the relevance to your question.
Well, the relevance is that the public will not know who owns this.
Can't testify, Miss Nanasi.
Do you
The
know,
witness can't ask the question.
do you know that all of the agencies in New Mexico, there's only one, the Public Regulation Commission, that is constitutionally mandated to regulate public utilities?
I believe I agree with that. I would imagine DEQ and others, EPA, I mean, there's probably others that have some regulatory jurisdiction, but I think you're referring to the primary jurisdiction.
Could you turn to your exhibit number 1, your revised direct, and could you go to PDF page 306 of your revised direct, which is
Okay.
And
Ms. Massey, are you finished with the deposition testimony that you had me looking at?
deposition. I
I mean,
haven't,
I'm sorry,
Interrogatory.
interrogatories.
for right now, yes, I am. Thank you.
Okay, and then I'm sorry, which exhibit?
Could you go to your revised direct, PDF page 306, which is JMB3?
I have that. Is that the GDP?
No, sir. It is
I only have 118 pages in my direct. I think you said 300.
page PDF page 306, JMB3.
Is that the structure chart?
Yes, sir. Tell me when you're there.
I'm there.
Okay, could you just read the title of this structure chart?
Corporate ownership of New Mexico Gas Company, Inc. Attachment A.
Thank you. And now can you go to your revised direct on page 10?
This is, let's see. My revised direct on page 10.
Yes.
Yes, ma'am, I'm there.
Thank you. On line 4, you state, in discussing how BCP portfolio companies are managed, you state, quote, in this and other transactions, BCP brings to bear ownership expertise and relies largely on the local management team to run the business. Did I read that correctly?
You did.
Can you turn to page 9?
Yes, I have it right here.
And on the second line, you state, if the transaction is approved and closes, NMGC will reside in the BCP Infrastructure Funds segment of BCP's portfolio of investments and will enjoy the benefit of prudent, financially sound, and experienced utility owners and operators. Is that correct?
Yes, yes, that's correct.
It's your position in this case that if the application is approved, that the NMGC's IT system will be operated and managed by BCP's Delta Utilities, correct?
And the IT services, the shared service component of the IT, those services will be provided by Delta Utilities personnel, correct?
Okay. And now can you go to New Energy Economy Exhibit 3, which is a printout of BCP's website under the tab Portfolio. Do you recognize this?
I'm sorry, is there anything on these charts? Am I finished with that one, or should I still have that one available?
Still have what one available?
You asked me to review the corporate ownership, the Exhibit JMB3, but I don't think you asked me any questions about it.
I asked you to read the title of it, and you did. And so now we're on to New Energy Economy Exhibit 3. This is a printout from BCP's website under the tab Portfolio. Do you recognize this?
It looks like it could be taken from the website. I don't know if it's accurate. I'd have to look at the exact website. I don't know if this printout is accurate to what it looks like on the website, but I'll take your word for it that you pulled this from the website or printed it from the website.
Okay. The first paragraph in this BCP's portfolio tab talks about that BCP proactively identifies attractive investment opportunities by relying on its strong reputation built over decades of operating and investing in infrastructure services. Is that correct?
No, that's not what the sentence says. You've only selected random. You've left out a number of words in your reading.
I didn't read it verbatim, but is that how I summed it up? Is that correct?
I would say it says what it says. You read a certain part of it and some of the words of it, but that's not what the statement says.
But it does say that you rely on your reputation is built over decades of operating and investing in infrastructure services, right?
That's what it says, correct.
Okay. The second paragraph discusses your blueprint for success and your blueprint approach to business, right?
That's what the words say, correct.
Okay. And you say here, we look to change a market, not follow one. We start with a plan and then pursue our vision. Is that right?
That's what it says.
Would it be fair to say that the way BCP describes itself to the world on BCP's own website is that BCP seeks to invest in and then influence its portfolio assets via operational control?
No, I don't know where you're getting that from.
Well, it says then the way that that why BCP's investments are attractive is because you have decades of operating and investing prowess, right?
No, it says our reputation is built over decades of operating and investing in infrastructure services.
And isn't what this means, how would you describe what your blueprint is? What is
The
your
blueprint? The blueprint is a moniker that we use to our development of various investment theses. And we follow a blueprint that's based upon a theme, and then the portfolio companies within that theme will follow the blueprint. So for example, we have a blueprint surrounding regulated utilities. And so we build on that blueprint by acquiring natural gas utilities and water utilities and eventually additional utilities that fit within that blueprint. And that's what our blueprint is our approach, is that we start with a theme and then we build an investment thesis around a theme, and we call that our blueprint.
And so the only other gas utilities that you owned is the CenterPoint and Entergy, right? And you just purchased those, right?
Yes, we just purchased those.
Okay. Let me ask you about the first line of portfolio companies that are represented here in this array. Specifically about Atlas, which is shown on the first line, the third company in BCP's company of portfolios. Do you see that?
Yes.
BCP invested in Atlas in 2015, but BCP no longer owns Atlas, does it?
That's correct. That company was sold.
Looking at the second line, what about Bernhard? When one presses the link there, it says that BCP invested in Bernhard in 2014, but its status there too is exited. So BCP no longer owns Bernhard, does it?
It sold that. That's correct.
And then continuing down the rest of that same second line, BCP also invested in Chara Solutions, and that's spelled CHARAH for the record, in 2017, but it is no longer invested in that company either.
It sold Chara as well.
Why does BCP have companies listed on their portfolio page that it is no longer invested in?
Because they're demonstration of our successful investment and disposition of assets. So that's why you'll see there, if you listed, you see all current realized infrastructure services. Those are different ways to sort those, but realized investments are investments that you have finished the investment cycle on, means you have acquired them and then eventually sold them. So those are very successful investments, and there are very many of them in the BCP history, and then that is it's a very common representation in private equity investing.
Even though BCP does not own New Mexico Gas Company, BCP lists this company as being part of your portfolio, correct?
There's a footnote that says it is not yet acquired, and you do not have that in this. There's a note on the website that's why I'm saying this does not look like an accurate representation of the website, but there's a notation that we list announced transactions on the website, and we identify them as such on the website, and we answered a bench request to explain that.
Can you put that one away?
Okay, thanks.
For the record, this is joint applicant's response to New Mexico Department of Justice first set of interrogatories and request for production of documents, at least some of those interrogatories.
Yes, Ms. Nasty, I have it.
So the first interrogatory that's here is one that you answered, NMDOJ 1-3, correct?
Let's see. It looks like, yes, I did answer that one.
In the same document, can you turn to NMDOJ 120? And this question, you were the respondent here as well, correct?
Yes.
And your answer here verified that BCP exited from Atlas, Chara Solutions, and Bernhard, correct?
That is correct.
Before leaving this document, can you confirm that you were also the respondent for NMDOJ 1-4, 1-18, 1-19, and 1-38?
Can you repeat those, please?
Sure. 1-4, 1-18, 1-19, and 1-38. And we've already discussed 1-3 and 1-20.
So yes, I was the respondent for 1-4. For yes for 1-18. I was the respondent for 1-19. And 1-20.
And 1-38, you were a co-respondent with Mr. Shell and Ms. Hutt as well, correct?
That is correct.
And your self-affirmation is attached to this document where you state, where you affirmatively state that you know the contents of your respective responses and that they are true and accurate based on your personal knowledge and belief. Is that right?
That is correct.
If you could specifically look at 1-38 and as of the date of this answer, which was December 17th, 2024, the question posed by the Department of Justice was, please provide an estimate of the cost incurred to date by all the parties relating to the proposed transaction. And if you add the 3,095,000 and you add the 2,305,000, it comes to approximately 5,400,000. Is that correct?
I'm sorry, I'm not sure what you're adding to the.
Well, the total on what is PDF page 16, but page labeled 53, and then the following page.
I'm confused.
So PDF page 17.
Oh, okay.
and then
I
PDF
see.
15. And if you add those two numbers, it's approximately 5,400,000. Is that right?
Yeah, but I'm assuming that's right math wise, but I didn't sponsor the top table. I think that's Amera's table or New
Okay.
Mexico Gas table. I would have sponsored the bottom table.
Okay. So, but I am just asking about the math for this question. That equals approximately 5,400,000. Is that correct?
I haven't done it with the calculator, but I will take your word for it if you're saying that's the sum of those two numbers.
Yeah. And that was way before joint applicants added the 3 rounds of testimonies from Misters Miko and Tuminello, Dr. Talley, Ms. Kelly, Ms. Quilici, correct?
Yes.
What is your understanding of the amount BCP applicants have spent thus far in this case?
I don't know the exact amount, the updated amount, but it's probably in the realm of 20 million by this point.
And that's more than twice as much as the BCP applicants have promised to low-income ratepayers in this, correct? Is that right? In this case, correct?
I don't think those two numbers correlate.
Well, I'm making that correlation because you've offered $7 million for low-income ratepayers as a benefit, and you've spent $20 million to on this.
Yes, these are costs that we incurred. We incurred these costs, and we're incurring additional costs to provide the benefits. So, I'm not sure I understand your point, but I would agree with your math.
Can you now turn to New Energy Economy Exhibit 4?
They now have me with 2 computers to keep up. So now is this it looks like another maybe a picture from the website.
Yes. Here, the heading for the tab is BCP's strategy tab, a plan for building value. Do you recognize this?
It does look like it could be a page or at least an excerpt of something from the website. So it looks familiar, yes.
Okay. One of the things that it says on your strategy tab, and you can even see that like the strategy word in the picture is highlighted there. You see that?
You mean it's green as opposed to white?
Yes.
Yes, I do see that.
Okay. And then this is about like the first heading says strategic investments in essential services and infrastructure, correct?
Yes, that's correct.
And the first paragraph that's highlighted there in larger font is that BCP explains that it accomplishes its goals by maintaining price discipline and developing value creation. Is that correct?
I would say that is a classification made by you of the language. It's not exactly what the language says, but that's part of it for sure.
Okay. Now, is the way that if you could go down to the next page where it's entitled Value Added Infrastructure Investments. In the middle there, it says, quote, our approach involves working closely with management to reduce costs, better manage capital plan execution, and increase reliability, right?
Yes, it does say that.
Now, I noticed that you were at the public comment period for this case, right?
Yes, I was.
And you heard a healthy skepticism from the public about private equity and people's fear based on private equity buyouts in the housing, healthcare, and even veterinary services that public equity companies are there to extract wealth from companies by reducing costs via reduction in staff, right?
I heard about 30 people, and some of whom made comments about private equity based investments. Those are actually different than infrastructure investments. But I would still disagree that whatever specific references they might have had to particular their view on particular investment doesn't relate to an industry as a whole, and infrastructure investments are not what's typically defined as private equity investments.
But that's not what the people were saying. The people were saying that private equity comes in the housing field, in healthcare, and even veterinary services, and that they were skeptical about private equity's commitment to the public interest, and one way of doing that
Let's
was
break it up. It's going on and on and on.
Yeah.
okay. So,
Madam Hearing Examiner, I would object to this line of questioning. One is, Ms. Nanasi is testifying, but we're also dealing here with public comment, which under the rules is not evidence. And so, what transpired in the context of public comment is public comment and, properly considered in its context, but I don't think it's appropriate to engage questioning of the witness about, representations, what was said at the public comment hearings.
Ms. Nanasi?
this is cross-examination. It seems like I could ask him about it. It's actually an intro into the rest of my questions about this. I'm asking him what he observed at public comment and what
Okay, let's just stop there then.
Okay.
You were at the public comment, Mr. Baudier. You
Yes, Your Honor.
observed it, and it's been characterized as not everyone was supportive. Does that give you any pause?
No, it does not, Your Honor.
What were some of the things that people raised fears about in particular about private equity?
Again, I object. We're trying to get public comment
Yeah.
now, and it's, Your Honor.
Yeah, I'm going to sustain that objection. Move on, Ms. Nanasi.
You believe that New Mexico Gas Company is well managed now, correct?
Definitely.
Why wouldn't BCP agree to keep all New Mexico gas workers for the full 10-year hold rather than for only 5 years?
That was recommended by one of the interveners. We thought 5 years was reasonable. It's certainly a long period to make a commitment to all employees and including adding employees. And so we believe that's a very strong commitment. At some point, the management would need to feel, I'm not saying that there would ever be plans to reduce workforce. Hopefully, we'll grow the workforce as we're doing. I will point out that it was not private equity that let go 100 people at the last acquisition. That was a publicly traded company that did that. And so we create jobs. We don't take jobs away. And we're creating more jobs for the state of New Mexico, and that's demonstrated in the expert testimony of Dr. Erickson.
Mr. Hold on just one second, Ms. Nanazi. Mr. Baudier, does that commitment to 5-year commitment, does that extend to the management of gas company?
It certainly does not make exceptions for management. I believe the only exception that or qualifier on that commitment is that there can be a termination for cause.
Right.
But yeah, it doesn't exclude any employee.
Well, so there's nothing, for example, then that, or is there something in this structure that would encourage current management people like Mr. Shell and to remain?
Certainly we have promised all of the employees that their benefits, pay, and entire packages will be at least as good as they have been. So the way we say it, and we apply this to all of our portfolio companies, same or better. And so, I would urge you to ask, Mr. Shell's opinion, but our reaction from the employees has been overwhelming optimism for the new acquisition by the Barnhart Infrastructure Fund.
Thank you. Go ahead, Ms. Nasi.
If you're so confident that you're going to be the same or grow an MGC, why not, other than for cause, why not keep the NMGC employees as they are for 10 years, for the entire hold period?
We believe that the 5 years is a very reasonable period to make that commitment.
You're about at 10 minutes out of your 2 hours. Just to give you a placeholder.
Okay, well, it seems like then I will stop at 5 if that's when you say, and then I would like to resume and figure out how I'm going to cut from others for tomorrow morning. Back to New Energy Economy Exhibit 4. Can you move down a couple of pages and could you please read BCP's Our Blueprint Approach? That paragraph?
You want me to read the entire paragraph?
Yes, please, sir.
Yes. The title is Our Blueprint Approach. And then the paragraph starts, Our Blueprint Focused Approach is the method by which BCP seeks to identify desirable specific subsectors of our core infrastructure industries. Then, through deep research and operational insight, we develop a top-down analysis with the goal of capitalizing on specific strengths, growth opportunities, and sector inefficiencies. Our in-house operational experience is integral to our blueprint approach. We leverage our institutional knowledge and networks to identify companies and management teams that we believe are well positioned to capitalize on these overlooked inflection points to create significant value.
Sir, I don't think that you read one word right. You said on specific strengths, but I believe that it says in this document on specific trends.
I'm sorry, where is that?
Right in the heart of the middle of the paragraph.
Oh, it says capitalizing on specific trends.
Thank you.
If I said strengths, I read it wrong.
Would you say it is fair that what BCP is saying is that BCP's management's top-down analysis of its companies and your operational experience is the key to leveraging change and your investment success? Would that be a fair characterization of this paragraph?
No, it would not be.
Tell me why not.
The top-down analysis is not of the company, it's of the trends in the industry and opportunities and sector inefficiencies. So this is a reference to our approach to an entire industry.
Okay. That analysis is central to your investment success. Is that what this is about?
Yes, this is.
And then if you could go further down, under the picture, it says, this reiterates BCP's industry insights and disciplined, thorough strategic, operational, and financial evaluation of each investment opportunity. Is that right?
That's what it says, correct.
Okay. Under the next paragraph, advantaged sourcing, BCP again reiterates its prowess for operating improvements and executing BCP's blueprint analysis, right?
I'm sorry, where are you referring to?
Well, under the advantaged sourcing, he talks about the potential for operating improvements and executing BCP's blueprint analysis, specifically under bullet 2.
Oh, I was looking in the paragraph that you were referring me to. Obviously, the word operating improvements is in the first paragraph. And in the second bullet, it says proactively pursuing investment opportunities because of BCP's blueprint analysis. And that would refer to the identification of a sector and pursuing investment opportunities that match with that overall analysis of the sector.
And who makes these BCP blueprint analyses?
These are part of what our entire staff does. That's what our jobs are, is to find opportunities and develop blueprint theses that will create investment opportunities that make the most sense for our investors.
And this is it done through BCP's portfolio committee? I think you referenced that with Mr. Gould.
No, I don't recall referencing a portfolio committee. I don't know what that is.
How about the investment committee?
And the investment committee is is a committee designed to make specific investment decisions. The blueprint, the finding of opportunities can be done by anyone within the organization.
And doesn't it
That's what our jobs are.
Okay, sorry to interrupt you. Doesn't it say further down, BCP's portfolio committee meets quarterly to review BCP's companies, etc.?
Where do you see that?
Like 2 pages down.
I see reference to investment committee.
And
But
keep going, it's under title portfolio committee.
yeah, that's portfolio company review. That basically consists of the entire firm, except for administrative staff, all of the people involved in the investment part of the business.
And does that include Bernhard Capital Partners Management?
That is Bernhard Capital Partners Management.
And then at the end of that portfolio committee, it says after it lists all the things that you like, the plan that you follow, it says at the end, you create an analysis of potential realization strategies and evaluation of capital market and exit opportunities, correct?
That is correct.
And then the last thing on that page is, other than just identification information, is that then you exit, right?
It doesn't, it's a word exit. I don't know what it's exactly referring to here.
Well, does it follow what is right before it called exit opportunities?
It looks like it's another heading. I don't know, it could be to exit the website. I'm not sure what this is. I don't know what it is in this context.
The bios of the Bernhard Capital Partners Management is also listed on the website, is it not?
Yes, it is.
And the bios of the BCP management are all financial and legal, but they have no specific regulated gas utility experience, do they?
They're not all financial and legal. I would disagree with that. But we talk about our utility experience in my testimony. But regulated gas experience specifically, I know Foster Duncan has it, but yeah, I don't think we reference other than the acquisitions of Delta and Magnolia as operating gas, specifically gas utilities.
Do you want me to stop here, Madam Hearing Examiner, or go into another area?
Well, we have reached the 5 o'clock hour. Do you believe that you are going to be able to finish in the next 10 or 15 minutes?
Absolutely not.
Okay. Well, then perhaps it might be a good time to recess for our first day. And we will begin tomorrow earlier. We will begin at 9. People can check in at quarter of, and I will be on more quickly for our earlier than that for a court reporter, but I have a couple of to-dos. I'm gonna move the 2 orders that I took administrative notice of to the Dropbox, and we'll also email the parties the worked upon cross time document. And I see Mr. Gould, you've changed.
Sorry, Madam Hearing Examiner, it's Joseph Yar.
It
Mr.
is
Gould just,
Mr. Yar.
Mr. Gould stepped out, figured I wouldn't log in on a separate one and just use his link. I think you answered the question, Madam Hearing Examiner. I believe you just indicated that you would be circulating a list of the order of cross that would be coming up, so I could prepare for tomorrow.
Okay. The order of cross was stipulated or agreed to by the parties. And for joint applicants witnesses, after Ms. Nanasi would be WRA, CCAE, FEA, and staff is the order. But that wasn't the much worked upon document with Ms. Kippenbrock and myself that actually has the cross times in it. And that's the one that I said that I would go ahead and send out.
The super secret one, yes, ma'am.
Yeah, that's not really secret. But no. So I've just had to scan it because it had some other things with it, and I had to separate it out. And I will do that. Do we have anything else procedural that we need to discuss before we recess for the evening? I'm not hearing that we do. Thank you all very much. We had a little bumpy start, but I think we have we're in the flow now, and I am going to begin with one procedural thing tomorrow. I set forth the event of the commission's public comment. I did not memorialize as of yesterday, the 56 comments that are in the record that I read. And I want to briefly acknowledge the time and effort that people put in to provide those comments to the commission. So with that, hearing nothing else, thank you all very much for your efforts, and we will be recessed until 9 o'clock tomorrow morning. Thank you all.
Thank you.
Thank you very much.
Thank you.